I believe we're ready whenever you are.
Okay. Good morning, everybody.
Oh, can you unmute us?
Good morning.
I will call the meeting to order at 9:03. If you can please all stand and join me in the flag salute. Put your right hand over your heart. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. You may be seated.
Mhm.
City Clerk, can you take roll, please?
Mayor Lopez,
Here.
Mayor Pro Tem Ibarra,
Here.
Councilmember Davis,
Here,
Councilmember Menke,
Here.
Councilmember Gonzalez.
Here.
You have a quorum.
Thank you. City Clerk, do we have any changes to the agenda?
There are none.
Thank you. May I have a motion to approve the agenda?
I'll move.
second,
Motion by Mayor Pro Tem Ibarra, seconded by Councilmember Davis to approve the agenda. I'll call the roll. Mayor Lopez,
Yes.
Mayor Pro Tem Ibarra,
Yes.
Councilmember Davis,
yes,
Councilmember Menke,
Yes.
Councilmember Gonzalez.
Yes.
Motion carries.
Thank you. Now we will take public comment from members of the audience. If you would like to provide public comment through Zoom, please click the raise hand button. At this time, the public is encouraged to address the City Council on any matter that is within the subject matter jurisdiction of the City Council. The public will also be given a chance to comment on matters which are on the posted agenda during City Council deliberation on those specific matters. Is there any public comment? City Clerk, do we have any public comment?
Who is that? Just a minute. I believe we do have one.
Okay.
Leticia Wilson. Leticia, go ahead.
Okay, can you hear me?
Yes.
Okay, good morning, Madam Mayor and members of the City Council. My name is Leticia Vasquez Wilson. I'm a member of the Central Basin Municipal Water District Board of Directors. And I was calling today regarding the upcoming appointment to the Central Basin Water District Board of Directors. As you are aware, AB 1794 required the changing of our governance structure at Central Basin, therefore allowing 3 members of our purveyor community, which includes the City of Vernon, to be represented on our board. It has been approximately 3 years, in fact, since that has happened. And so we're coming up for a new election, or actually a new appointment by the purveyors. And I simply wanted to remind you that your previous choice for the cities was Mr. John Oskui, who in fact led an effort to pass a meter charge on behalf of the board. I didn't support it. And consequently, I believe it was 2 or 3 months later, and you're actually represented by that particular individual that represents. And so Central Basin, approximately 2 months after he led an effort to approve a meter charge, which imposed an additional fee on all the cities and the private water companies that are serviced by us. A number of cities in turn filed a lawsuit against the agency, which I wanted to remind you of, so that as you choose your representative, I want to encourage you to communicate with them to minimize the likelihood of litigation between the parties. This litigation, which has continued beyond the meter charge litigation, has cost our ratepayers millions of dollars. And so I wanted to come to your council to express that to both the mayor and the members of the council for your consideration as you move forward on your appointments to the Central Basin Board. Thank you for your time and have a wonderful day.
Thank you. City Clerk, do we have any additional public comment?
That appears to be it.
Okay, we will now go on to the presentation items. Presentation item number 1.
Item number 1 is Employee Service Pin Awards for December 2020, and Human Resources Director Earl will present the report.
Good morning, Mayor and members of the City Council. During the month of December, we had 2 employees achieve service milestones with the city, both from the police department. First, we'd like to recognize Gustavo Herrera for 20 years of service to the city. Mr. Herrera was hired as a police officer in the police department on December 4th, 2000. He was promoted to police sergeant on July 8th, 2018. And we'd like to recognize Mr. Herrera for his 20 years of service to the city. Next, we have Nicholas Perez, also being recognized for 20 years of service. Mr. Perez was hired as a police officer on December 4th, 2000, was promoted to police sergeant on July 1, 2013, and then promoted to police lieutenant on July 8th of 2018. And we'd like to congratulate Nick Perez on 20 years of service to the city. Thank you.
Yes, congratulations to them both. Thank you, Michael. And we will now go on to item number 2.
Item number 2 is review of process for amending the Vernon City Charter. And Interim City Attorney Alvarez Glassman will present the report.
Good morning, Mayor and council members. First of all, Happy New Year and hope everyone is well and safe. This morning, I will be presenting a brief report on the process for amending the AA City Charter. If you recall, at the goal setting and team building sessions with the council had requested a presentation on how a city goes about changing a charter. And this morning, while we won't be discussing any substantive changes, I will walk the council through procedural changes or procedural steps in order to make any changes. The California Constitution requires or allows that a charter may be adopted, revised, amended, or repealed by a majority vote of its electorate. The manner in which a charter may be amended or changed is through 3 different ways. One is via an initiative petition by the electorate. 2 is via a charter commission. And the 3rd, which is the most common, which are changes to the charter adopted or approved by, recommended by the city's governing body, in this case, the city council. I'm not going to discuss too much about the initiative process, but if there was a request for a change that obtained the required number of signatures, it could be presented to the council and then placed before the electorate. On the second way, probably the most common manner in which a charter could be amended or changed is by action by the city council. In this situation, the city council would review sections of the charter that the council believes should be amended, that they would discuss it and approve it at an open meeting by a majority vote of the city council. And at that time, those amendments would then be presented to the voters at a regular or special election. That is, if the electorate approves the proposed changes, then they become the new language of the city's charter. In some instances, cities opt to form a charter commission. I've been involved in that type of approach, where council could appoint individuals to serve on a charter commission to review and make suggested recommendations for changes to the charter. That can either be council appointed or voter approved commissions. Again, the commission would then present to the city council the proposed changes. The city council would then place those items before the electorate. And if the electorate approves those changes, then it becomes the new language to the city charter. With that, unless there's questions, I don't believe I should need to get too much into the details of when you would need to hold an election, since we're at the very early stages of this process. But I'm happy to address any questions, Mayor or Council, regarding this brief presentation and how a charter is amended. Thank you for your time.
Is there any questions? Seeing that there are none, I'm sorry?
Mayor, if we're going to go forward with this process, then we would expect some direction later on by the city council, and then we can review specific sections or areas of the city charter that may need modification. That's the extent of my presentation. Thank you, Mayor.
Thank you. We will now go on to item number 3.
Item number 3 is regulation of commercial cannabis businesses, state law authority, local regulation, and policy considerations. And Assistant Interim City Attorney Capado will present the item.
Good morning. Are you able to see this on your screen?
Yes.
Mhm. Yes.
Yes, we see it.
Great. Okay, good morning, and thank you so much for giving me the opportunity to present this morning. Mayor, members of the council, it is my intent today to give you a general overview of the state regulations and local authority and certain policy considerations to take into account should a city, and specifically City of Vernon, consider implementing a program. There's a lot of information. So what I am suggesting is that if at any point you want to have me slow down, or if there's anything specifically that you want me to focus more on, I'm happy to do so. So the general overview is to give you a roadmap of what I will be presenting this morning is we'll briefly discuss the state law regulating commercial cannabis business and the state licensing cannabis classifications. Then we'll move forward with local regulation and what is the current local jurisdiction and authority for cities to implement such a program. I'll also be sharing with you some information on other municipal jurisdictions, including cities in the surrounding cities immediately adjacent to the City of Vernon. Also based on our experience, there are some policy considerations that any jurisdiction should consider if you are a program or an ordinance within a jurisdiction to allow commercial cannabis businesses, and we'll go through some of those. Also, just based on our experience, we do have affirmative recommendations in the event that the city may consider at some point to implement a program or direct staff to draft an ordinance. And lastly, we'll give you an opportunity to ask any questions, provide any comments, or provide any direction to the city attorney's office or staff. So in the state of California, it was first, this topic was first introduced in 1996 with the Compassionate Use Act, and that was specifically for medical marijuana uses. In 2016, it was a ballot measure that was presented to the state, and it was Prop 64 that was passed, and it was known as the Adult Use of Marijuana Act. Since 2016, there's been a lot of different amendments and changes to the state law. I won't get specific as to that because it is a lot. But since 2006 to the present, there's been different main provisions, and specifically, there has been a merging of the marijuana regulations and the adult use and merged into one. I thought it was important to highlight here that in 2006, when Prop 64 was introduced to the state, statewide, 57.40% voted yes. And LA County, it was 59.5% voted yes. Specifically as to City of Vernon, 53% voted yes. Since 2016 to now present 2021, we have noticed in various provisions or cities that those numbers have increased, and we think it's a matter of communities getting more comfortable with the idea that this is an industry that jurisdictions are regulating. So as mentioned, currently now, as we know it, the specific law that regulates cannabis in the state is called Medicinal and Adult Use Cannabis Regulation and Safety Act. And again, it's merging of both the former programs that existed with the current programs of regulating both medicinal and adult use cannabis regulation. And just to kind of have a specific overview, commercial cannabis, the activity is specifically defined in the in state law. With any license that is issued by the state, they have to operate lawfully. And one of the main specific provisions is that the state will not issue a license unless the operation completely adheres and complies with local regulations. So assuming that a city doesn't allow for commercial cannabis regulations, then a state will not issue that operator a license, even if they submit that application. There are 6 main classifications that is regulated by the state, and these are specific business activities. The main classifications are cultivation, manufacturer, distributor, testing laboratory, retailer, and micro business. And while I will give you an overview of some of these classifications, in total, I believe there might be 21 to 23 types of classifications. So what you'll find is you'll find subsets within each of these general classifications. Currently, there are also 3 different agencies in the state that regulate and issue the licenses depending on the classification. So the first classification that we have is cultivation. Cultivation, you have a mix of small, medium, or large operations. You have specialty cottages, you have nurseries. You also have indoor cultivations and outdoor cultivations. Typically in areas that allow for outdoor cultivations, it's typically very agricultural and typically up north. In urban areas and in areas that are more of LA County, typically outdoor cultivation is prohibited and only indoor cultivation is allowed. Manufacturing, I would say, is the broadest. I'm sorry, does someone have a question?
No.
The broadest, in my opinion, of classifications is manufacturing. This is where you have a gamut of you're extracting the cannabis, you are undertaking chemical synthesis, you are repackaging cannabis, you are cooking cannabis. So this is, I think, the broadest of all of the classifications. You also have distribution. Distribution is typically where you are transporting the cannabis or cannabis product from one licensee to another. So it's different from a delivery. Typically what we find is that some cities don't allow this as a main classification, but as an ancillary use to other main classifications such as manufacturing or cultivation. And again, this is from transporting or sale from licensee to licensee. Then you have a testing laboratory, which is pretty straightforward. This is where you are actually conducting the testing and performing tests on the actual products. The state requires very specific regulations concerning the regulations and the accreditations of these laboratories. One specific a feature of a testing laboratory that is different from other classifications is that if you are a testing lab, you are not allowed to have other uses. In comparison to the other ones, you are able to have one or various different uses or classifications under one roof or in one premise. You also have retailer. Again, you have different subsets of retailers. And this engages the retail sale and delivery of cannabis or cannabis products to customers. There are two main categories in retailers. You have the storefront retailers that are open to the public. These are commonly known as dispensaries. Then you also have delivery only retailers that are close to the public. So here there is no foot traffic. There are no customers coming into the premises. Instead, you are ordering either online or via phone, and the employees of the operation deliver the cannabis. There are 4 different classifications that are allowed under a micro business umbrella, and you at least have to have 3 classifications under micro business. There are cultivation, which has to be less than 10,000 square feet. You have manufacturing, distribution, and retail. And again, because they're different subsets, you are allowed to have different types of some of these classifications, again, so long as the underlying city or jurisdiction allows for them. There's also, there's a lot of examples of state license application requirements that I listed. I don't intend to go through all of them. What I did is highlighted the main ones, and it was also an example to provide that this is an industry that is heavily regulated by the state. Any jurisdiction that decides to adopt a program or implement a program, our recommendation is always that you implement the minimum state requirements and add additional. So the idea is that if you at least incorporate the minimum state requirements, you're already gauging the type of operator to ensure that they at least meet the minimum state requirements, so that if they go through a local process and when they finally go and apply through to the state licensing program, that typically it'll be a streamlined process for them, because we have already asked them to comply with all of the state regulations. So you have things like you want to ensure that they go through a criminal background check. You ask for their fingerprints. You also provide or ask that they show a legal right to occupy and use the premises, whether it's through a title or a deed document. If they're renting, we want a copy of a lease. And obviously we also want an explicit authorization from the property owner that it's notarized, that they're allowed to use the premises, and that they are familiar with the city's program. Also, at any point where you have 20 or more employees, they are supposed to provide a statement that they will abide by a labor peace agreement. Obviously, in the beginning, if they're submitting an application and obviously they still don't have employees, we want them to at least submit a statement of intent that at the time that 20 or more employees, that they do employ 20 or more employees, that they will abide by a labor peace agreement. Again, these are minimum requirements. Nothing precludes a city or local jurisdiction to being more stringent. You also want to ensure that you implement operating procedures. These are things like inventory procedures, their quality control procedures, security procedures. Also for cultivation, water is a big component of cultivation. So we want to ensure that they are able to identify their water sources. they're supposed to submit a diagram of their proposed premises, so we know exactly where the entrance are, where their storage is, if they have different classifications, that they designate each portion of different premises where they're going to have the classifications. We also want them to show a complete list of the people that will have a financial interest, and that is disclosed in their application. A very important component from a local jurisdiction perspective is that the state has identified 3 different sensitive sites, and it requires a minimum of a 600-foot radius from the licensed premises to these sensitive sites. Currently, the 3 sensitive sites that the state has designated are schools, daycare centers, and youth centers. Again, a local jurisdiction is authorized to specify a more restrictive radius, meaning that it can be more than the 600-foot radius, and it could also designate additional sensitive sites. It's my understanding that we only have 1 school in the city of Vernon, and then there's also a church in the city of Vernon, but I believe they're right next to each other. So one of the things that we also recommend, that I'll discuss a little bit further, is that jurisdictions also take into account residences, so that you designate residences as well as sensitive sites to also include that and create that buffer.
Norma, I have a quick question, sorry.
Yes.
On the state licensing application, how intensive is it to get a license from the state? How bad is the background check and everything?
It's pretty intensive. It's pretty rigorous. They have to go through a criminal background check. The state has minimum requirements as to what type of criminal activities will be prohibited, what are allowed. The state also allows for the applicants to submit an explanation to say, yes, I was convicted for X, Y, and Z, but that was 15 years ago. The state allows for waivers in that regard to see if people have rehabilitated. Again, that's something that a local jurisdiction doesn't have to do. But that's why I wanted to include some of the state requirements because it is quite rigorous. The application is quite extensive. It requires operating procedures, odor control procedures, security protocols, their inventory protocols, a lot of information about the specific operators and applicants. So that's why one of the things that I would recommend is that at minimum, any local jurisdiction incorporate the state regulations, because already from that perspective, it's a very comprehensive and stringent regulatory process. So my idea is that if they're able to comply with local application requirements that incorporates all of the state licenses, then you're almost setting them up for success, because they've already gone through a rigorous program locally that they can now adhere to the state regulations. Does that answer your question?
Yes, thank you.
So again, I listed additional state license state requirements as well here. One of the things also with regards to advertising or marketing, the state is very specific that any advertising is not allowed if it's intended to encourage persons under 21 years of age, that none of the advertising is attractive to children. And also if you have advertising signs, that they are no less than 1,000 feet away from those sensitive sites that we discussed, such as the daycare centers, schools, playgrounds, and youth centers. This is the explicit authority that the state provides local jurisdictions to either allow for a licensing program, whether it's through implementing business regulations or zoning and land use requirements. It can allow for some classifications, all classifications, or it can completely ban any of the classifications or the industry as a total. And again, here is the explicit state authority saying that a local jurisdiction may establish additional standards, requirements, and regulations. So nothing prohibits the state, a city or local jurisdiction from being more stringent. Specifically to discuss what Vernon is currently doing. Currently, section 26.4.1, section 5B of the Vernon Municipal Code indicates that uses that are prohibited or limited currently regulates that no dispensary, store, co-op, or cultivation operation is permitted in any zone or overlay zone. So in essence, for all intents and purposes, currently, the city of Vernon has a regulatory ban on commercial cannabis businesses citywide. As of 2021, in LA County, this is a list of the cities that currently allows and regulates at least one cannabis license classification. In the surrounding cities, we have like Bellflower, Commerce, Cudahy, Montebello. The cities that have an asterisk. In this presentation, I do have a little bit more of specific information as to these programs. So as you can see, even in LA County, which is such a large county, relatively speaking to other counties, there's still a limited amount of cities that currently regulate license classifications. In November 2020, we also saw various different ballot measures concerning cannabis. I highlighted here only in terms of LA County. Some of the cities implemented a cannabis tax measures and also implemented a program. So there's a couple here also that even though they don't have a program, they also decided to implement a cannabis tax measure should in the future they allow a program. And we noticed this trend, especially due to COVID and all of the implications, unfortunately, of COVID causing a strain on cities' budgets and resources. So I approached 3 different cities and asked them specific questions. Back in 2016, when the program was first starting to being implemented based on state law, there was very little information, and relatively speaking, it's still a brand new program. So even though you have cities that have implemented programs since 2016 and 2017, there's still limited concrete information. But I think at this point, we are at an advantage to be able to provide specific information. So specifically, just to review City of Linwood, they approved 19 different operators. The types of classifications that are allowed are up there in your screen. There's currently 6 businesses that are operating out of the 19. Just to give you a snapshot from the fiscal year of 2019 to 2020, they collected $196,000 in cost recovery fee. So these are one-time fees, they're application processing fees. Now the quarterly fees that they have collected, and this is from a quarterly basis, is $203,548. So assuming that their quarterly fees are pretty consistent, let's say they would be collecting about $800,000 on an annual basis. They've also collected $112,500 in transfer change and ownership. So we have seen a trend where either the existing operators decide to transfer ownership or change ownership. When they change ownership, what we're noticing is that they're adding additional investors into their setup. We wanted to also ask if there were current delays or obstacles that they're experiencing. One of the trends that we saw and that you'll see that we've asked is, unfortunately, because they don't have in-house county fire department, some of the biggest delays have been with the fire department in reviewing their plans. And also there is a perception sometimes that there's public safety problems that come into the cities because of commercial cannabis program. Across the board, what we saw was that cities have not had to address any public safety program problems that were specific to the cannabis program. Again, we asked if there was any relevant information that they wanted to share with the city of Vernon. Here, they basically said that to assist operators, they allow for a temporary certificate of occupancy while they get their permanent, again, because of no fault through them, based on the different approvals that they have to get with the county, they have noticed a slowdown. For Montebello, we asked, specific similar questions. Currently, there's 2 businesses that are operating and 2 pending licenses. So for a total of 4 out of 24 operators that have been approved. Currently, they have not received any operating fees because they just started to operate. Again, they have not experienced any safety issues with the 24 approved locations. One of the things that they've noticed, again, is that the approved operators are looking for additional investors. For the City of Commerce, out of the 45 complete applications that were received, 23 operators were approved. 7 businesses are currently operating. Right in your screen, you see the list of classifications that are allowed, including indoor cultivation, manufacturing, distribution, non-storefront retail delivery, microbusiness and testing. From their fees as of December 31, 2020, from their one-time fees that they collected, it was upward of $3 million. For their ongoing operational and non-operational fees. Now, this is the ongoing fees that this city collects from a revenue source is upward of $1 million. The City of Commerce also requires the operators to fund the city's community benefit program. This is a separate fund from the general fund. They have collected $846,000 and $820. So the grand total overall is upward of 4.9 million. Again, the hiccups that they have experienced with their operators is that there's a slowdown in the approval process from building and safety, fire department, sanitation. So they're trying to assist as much as they can from that perspective. Again, they have not experienced any public safety program problems through their program. And from their perspective, based on the fact that this is less than 2 years of actual operation, that they have made a healthy profit and they've reinvested in their city services through their community benefit fund program. So some of the considerations that policy considerations that we recommend that any city consider in implementing program is what type of classifications out of the 6 classifications that we discussed, the review and approval process of the program and of the applications and the operators, also what type of land use or development agreements or permits, licenses will be required, that we incorporate all of the state requirements, including the financial health of the applicants, stringent security plans. We do recommend that pro formas are submitted to the city to see what their financial health of their operation is, what zones will be allowed in the city, specifically what areas of the city will be allowed. And as we discussed, what sensitive sites would be designated, what are the buffer distance requirements, and also the tax and fee structures that will be imposed. With any program, we do recommend penalty provisions where the city has the authority to continuously monitor and enforce the operations. That also that there be an imposing a fee so that the city, as part of the application process, so that the city is able to enforce their city laws without costing the city. And as I indicated, that there's explicit provisions authorizing the city to inspect the premises at any time, to audit their records, and also to have penalty provisions, whether it be criminal consequences, administrative consequences. Currently, we are looking to make changes to the city's administrative citation program. So we would recommend that any violation would be anywhere from $5,000 to $10,000 on a daily basis, and those citations amounts would be paid to the city. The main fee structure, right, that typically exists is you have your processing fees that you pay the city for your application process, your application programs. So this would make sure that the city is made whole, that the city recovers any of their costs that it is incurring in reviewing the process, the program. Then you have the operating fees. This is actually the bulk of the revenue source that the city would receive. And these are typically either through a tax measure or ability to negotiate through an operating agreement, a development agreement, or a contract. And these would be ongoing fees. Another component of a city's fee structure and revenue source is that, as we discussed, some cities implement the Community Benefit Fund program. Some cities ask that the operators pay up to $50,000 a year to this program. And other cities we've seen anywhere from $10,000 to $32,000. Here, the city currently, Vernon has its own community fund. So should the city think about this program and wants also this component, the beauty of the city has already this structure that you are able to fund this program as a component to this program. Also, a unique position that the city is in is that it has its own utilities. So while there's very little literature on this, we would expect to see that the cannabis grow facilities would make up to any increase of the city's power demand. I won't get into the specifics. There's just typically if you do want to engage in an agreement, that would be the authority to, or the licensing scheme. A development agreement is a very good land use tool to be able to incorporate not only your land use regulations, but also your business regulations. Additionally, instead of a development agreement, the city can also implement an operating agreement along with a land use entitlement to be able to negotiate these things, such as an operating agreement. To negotiate your operating fees, as well as a community benefit fund. Here, I just gave you some examples of two cities that have their own programs and what their fee structures are. Specifically to what we discussed, they have their application fee, they have their development agreed deposit, they have ongoing review fees, and then typically what you will find is that for the different classifications, you have a range of a % of a gross revenue, and then you also have a payment of a community benefit program. So this is similar from like Cudahy and Linwood that we have examples here. These are the state taxes that, in addition to whatever local agencies would impose on a city, the state also has specific state taxing requirements and obligations for each operator. Here's another example of the city of Culver City. What I would recommend to any city is that instead of imposing a specific amount of a percentage of gross revenues, to give the city the discretion, is that you impose a range. So this here, what you have on your screen is a range of kind of an average of what you see in the city. What I've noticed now is that there's several cities that are trying to lower their fees to remain competitive. So that's why I would recommend a range of a fee as opposed to a specific amount, and giving the city the discretion to be able to change those fees to be able to adapt to the market and the economy. Here are the elements that we would recommend based on our experience of the type of things that a city should consider to implement in a program. Again, it's the business classifications. If there is cultivation, that it would be indoor cultivation, so that everything is contained indoors. That it would be manufacturing. If the city is considering retail component, that it would be non-storefront retail delivery. Think of it as an Amazon. Nobody comes into the premises, but the transactions are all done through the phone or online. That any classification, that any business is closed to the public. This allows the city to ensure that there's no foot traffic, there's no loitering, any of the typical concerns that cities have. This would be able to address those issues. Our recommendations at this point would be that outdoor cultivation is prohibited, that you have festivals be prohibited, that you have any dispensaries prohibited that are open to the public. Again, that the sensitive sites would be the same as the state, but you may also consider residences to ensure that you have that buffer with residences. And you also consider being a good neighbor, right? That if we may not have a school immediately within its jurisdiction, but if, let's say, it's immediately in the border of our physical boundaries, that we do consider that for other cities. Again, that we have minimum application requirements, that all of the state requirements be incorporated, that we do have stringent security plans submitted to the city. One of the things that we would require is that that the city's police department have the ability to log into their surveillance system at any point, and that their security guards be hired from a pre-approved, vetted security companies that the city would feel comfortable working with. Specifically, we would want the police department to be able to have a say-so in this regard. With fees and the revenues, we would make sure that a complete and thorough fee analysis be done so that the city recovers all its costs, that we have the ability to negotiate a range of operating fees through an operational agreement or a development agreement. And we would also recommend that a community benefit fund program be implemented. So here you're able to now fund other programs that perhaps your general fund program is unable to. And that that the licensing scheme again would be through an operational agreement, which is mainly a contract that the city would be able to negotiate with a land use entitlement. Here we would designate specific zones. So everybody knows these zones, you're able to establish a program and not in these areas in the city. And with the application and review approval program, that it be a merit-based and objective scoring criteria, and that a panel or a committee be put together, whether it be from interdepartmental directors or staff within our city, or also staff members from other cities, and that they have the ability to review and approve the programs or the applications to be able to operate within the city. So what I've done here is to list out at this point the options that the city has at this point. City council may direct the interim city attorney's office in conjunction with the city staff to continue to look into this matter, come back to city council to propose a draft ordinance with any of the components that we've discussed today or any policy considerations that our office or staff is directed. And we would bring back a draft ordinance at a later point at another city council meeting. So that would be the first option here. The second option is that you may provide direction to our office or staff to further research any component or issue that we discussed today, or if I did not raise anything and you have other components that you want us to look into, and that we would research those issues and report back to the city. Or the city council may decide to maintain the current ban on commercial cannabis businesses, and everything would basically be status quo. And or also with regards to this presentation, we could receive and file. Here, I don't know if Arnold wants to discuss anything further or add to it. But if there's anything else, now is the time to provide it with comments or questions, or give our office or staff any directives. And with
Mayor,
that,
I have nothing to add. Norma did a very thorough job and fine job. So we're open to questions or further direction from the council. Thank you, Mayor.
Thank you. Yes, it was a very thorough presentation. Thank you, Norma. Is there any questions?
I have a question, Norma. I noticed that in a few of the cities that the issues they had was LA County not approving plan checks in a timely manner. Maybe this is a city question, but now that we have LA County, where we went LA County, and we have plan checking is internal with Public Works and all throughout our departments. How does this affect our issues?
so one of the things that I have discussed this matter with administration and staff is that I think one of the things that, and staff obviously can supplement or add to what I discussed, is that one of the things that the city of Vernon currently has is as a liaison that would work with the different type of departments. So I think that's key, that if a program would be implemented, that we get in front of it and ahead of it so that we already are forecasting the potential problems, and that we are able to have this liaison to be able to say, based on the experiences from other cities, this looks like it's these could create delays. How can we make sure that we are more proactive and be able to be, quote unquote, business friendly, so that we are able to assist that, so that the city is not the one delaying the process.
I do believe that we have Chief Pappas available to speak on this issue, or she may have one of her designees talk on it as well. I'll turn it over to the chief.
Yes, this is Battalion Chief Richard Stillwagon, Los Angeles County Fire Department, Fire Prevention Bureau. Those cities like Linwood and Commerce were early entrants into the space and did have delays in their initial plan checks because the state of California hadn't set the regulatory guidelines. At this time, Los Angeles County has Regulation 30 in place to assist the business owners or the people entering this space with their plan check process. We have 3 designated inspectors that have been trained in this space and have been getting plan checks out in a reasonable time. So those early issues that we had, we believe we've overcome, and the process is streamlined to go through Commerce, and we've seen significant improvements in decreasing our turnaround times. So we don't foresee any holdups or hiccups in the future, and we'd like to work with the city. And the liaison idea is a great idea. It does help us facilitate plans back and forth. And with our Epic LA program, the transparency with the city and the customer really helps in that to facilitate that process. So I just wanted to speak to that very quickly. Norma, that was a great presentation. That's probably the best one I've seen so far. And thank you. Thank you, council and mayor.
Thank you. Norma, I do have one question. In regards like to the neighboring cities that have approved such programs, for instance, I did like, for instance, City of Commerce, like total applications received were 45 and then approved were 23, but then there's only 7 businesses currently operating. Is that correct? Like,
Correct.
there's a lot of people that are being approved. However, they're not actually up and running. Is that
Correct.
fair to say?
Yes, and that's one of the things that what we've noticed is that the cities that we've looked, that we reviewed it, that they haven't set a maximum, because what we've noticed is that with any industry, right, there might be a percentage that will fall off from the process. And so, so you kind of have a natural falling off of people that don't operate, and you'll see people that are either successful or not successful. And so one of the things that we've noticed is that a lot of these folks, in our opinion, should hire a project manager to be able to get familiar with the regulations, working with county, working with sanitation, working with hazardous waste, working with building and safety. So I think because they don't realize that this is a very heavy regulated industry. So that's where we've seen that it's taken them a while to operate. One of the things that I did discuss with staff, and one of the things that I would also recommend that the City of Commerce has done. So if you've noticed that in comparison to the other cities, Commerce is the newest program, yet they have 7 operators, while the other ones still have less number of operators, is that you have a non-operational fee. So the idea is you decided to apply to the city's program, so you are taking up space for a license, yet you're not up and running. So what is holding you back? So the idea is that the city wants their revenue. So either it's because you're up and running and you're already operating as soon as all of your approvals are given, or if for whatever reason you're the one that's causing a delay, then we impose a $10,000, upward of $10,000 fee on a monthly basis, so that at least the city is getting its revenue. And the idea is that hopefully that provides an incentive to the cities, is that you're paying the city, but you're not getting anything in return because you're not operating. So we are hoping that that creates an incentive for them to keep operating. So even though you see, like in the City of Commerce, it's only 7, relatively speaking, in comparison to other cities and how new that program is, it's quite successful.
Norma, I have a couple questions. How do you keep track of licenses or permits that we give out? Say, just like what she asked, 45 permits were approved, or the opposite way. Sorry, I don't have the numbers in front of me. How do you keep track that those are being used properly?
So you have what you would do is you would have internally some either designated staff that would oversee the program. You would, like with any industry, you would make sure that you have an ongoing basis to see where each operator is and at what stage you are, right? So like with the city that I've seen have specific information on all of the programs. So then you have designated staff that serves as their liaison as well, from the business operation to your city staff. And then you're able to monitor everything, right? And so when you implement your, like, okay, on a quarterly basis, we should be receiving X, Y, and Z. On a quarterly basis, we should be able to already receive their operating fee. On an annual basis, you should receive their community benefit fund payment. So you typically highly recommend that you have designated amount of staff, whether it's 1 or 3, or someone from each department that are overseeing the program. What we've noticed in other cities is that it typically falls under the kind of planning, building and safety, public works arena. to oversee the program.
Okay, and then I had a follow-up question for Battalion Chief Stillwagon. What's your current turnaround time with other cities on plan checks?
Depending on the complexity of the plan review, 2 to 3 weeks. So it really depends. What we've had trouble with in this space is our applicants have been confused on what they want to really do. Do they want a cultivation process? Do they want a chemical process? Those types of things have really created a lot of delays. And with our Regulation 30, it's really helped the customers streamline their process because they know exactly what to submit for. It answers most of their questions. It provides all the legal details for them to follow. And we've also seen a great deal of delay in, we give comments back to the customer. Let's say we have 20 comments. We don't hear from the customer for 60 to 90 days prior to resubmittal. So that's been an ongoing delay factor. So we believe that somebody who submits, if they have a chemical engineer who submits the plans within California State chemical engineer for a chemical process, those plans can be done within 14 days. If people choose to try to do that on their own or try to have LA County Fire consult for them, they're going to have delays because we can't be a consulting agency for legal reasons. So it just really depends on the applicant and the professionalism of the applicant. We've seen some people get through very quickly. We've seen other people be very delayed. So we try for a 2 to 3 week process.
Keeping our business friendly model in line.
Excuse me, Mayor
Yes.
Pro Tem.
Yes.
Chief Pappas would like to make a comment.
Okay.
Chief. Chief Pappas, if you could unmute yourself, you are able to make a comment.
Can you hear me?
Yes, now we can. Thank you.
Can you hear me?
Yes.
Oh, good. Thank you. Yes, I just wanted to let the city of Vernon know that fully supportive of any legal business operations within the city, and of all the cities that that we deal with in this division. I can tell you personally, I'm and so you have our assurances, and I was very pleased to hear from Chief Stillwagon and his staff, and we will help facilitate any legal business within the city. I would like to comment, though, on some public safety matters. We have seen an uptick, particularly in Linwood. Along with the legal cannabis businesses, you're going to get a lot of illegal and unauthorized businesses that are coming in. And we have seen that start to creep into the city of Linwood, and it has caused us some fire issues and public safety issues, particularly with the butane that's required in the honey oil processing, and particularly with electrical fires. But again, these are illegal operations. So just something to think about in terms of a public safety standpoint, that those issues might arise, and we're more than happy to work with the city on that. But from our end, we are fully supportive, and again, I have every confidence in Chief Stillwagon and his Fire Prevention Bureau that that we will be able to expedite things for the city. Thank you for your time.
Thank you. Does anybody else have any additional questions?
Mayor Pro Tem Lopez, sorry that I cut you off earlier. Ibarra, I'm sorry. Did you have a question?
No, she answered it. It looks like Carol has a question.
I have a couple questions. It looks like the City of Commerce is the most successful, to say the least, and should be a model for us to follow. I was wondering, what do you attribute that to? Is it that it's more cultivation, or where do you see that they're making more money, in what category?
So specifically, one of the trends that we noticed was through COVID, interestingly, I think just everybody's life, right, started to fall into this delivery, right? We get our groceries delivered, we get our food delivered. So City of Commerce does allow for retail delivery. So that's basically, again, the whole Amazon model where it's close to the public, but you have transactions and sales either through the phone or through the internet. So for commerce, the operations that have been the most successful are those non-storefront retail delivery. So what they looked at of that specific quarter was to see whether it was just a fluke, right? Or if this was a trend that was ongoing and that was more of the norm. So that's where we noticed that this past year, from March to the present, the non-storefront retail delivery has been the classification that has been the most successful. And also, you know, in terms of if you have cultivation or you have manufacturing, it's going to take a while, right, before they start to see revenues, and then in turn the city starts to see the revenues, as opposed to when you have your retail delivery, is they're not cultivating or harvesting the cannabis, they're not manufacturing, they're already working with a finished product and selling it. So that's one of the things that we've noticed. That city manager also has designated staff, I believe it's 3 staff members, to be the liaisons and to work with the operators. So each staff member is appointed the amount of operators so that you're continuously monitoring the progress and trying to facilitate. And again, I think some of those strict provisions of the penalty provisions, your strict non-operational fees, that if you're not operating, you're basically just taking up space, and hopefully that provides an incentive to ensure that you start operating. So that's kind of what I've noticed.
And that makes sense. We would also, I think, with manufacturing and cultivation, notice an increase in our power usage and water usage while it's growing, so to speak. With the delivery service, have you seen an uptick in crime at all?
No, and that's why we wanted to make sure that we asked that specific question from the cities so that it was coming from the cities. So there have been no uptick in crime or public safety issues. And again, with these non-storefront retail delivery and any operation, everything is close to the public. So there is no foot traffic, there's no patronage to the premises, nobody's waiting in the lobby, there's no loitering. So you're not getting those type of like concerns that you typically see in other cities with the illegal dispensaries per se. So that's the way you control it, and you ensure you implement these measures to avoid that.
And my last question, I realize that cannabis is still illegal federally. Do you still have to maintain a cash business, or can you bank your money now?
So, and you are correct. And in the staff report, I did make mention to it that, you know, the reality is that's what's happening, right? And so one of the things that we have noticed, and we do look at also, you know, the federal administration and the incoming White House administration has indicated that they do intend to decriminalize cannabis, to remove it away from this substance control designation. So that's one thing that we will continue to monitor, because it will be a game changer, especially in the financing component. I think because the different banks that cities currently work with, and you have that that already established relationship, there haven't been any problems. I think initially banks did start to ask, you know, we're getting these deposits all in cash. Can you give us an explanation as to why we're getting these cash deposits? Our office would come in, provide a letter to the bank and say, the city has a legal commercial cannabis operation. These are their legal obligations to the city, and that's what it is. And as soon as we provided an explanation, we haven't had any problems.
Thank you, Norma. You truly are the expert on this. I mean, that's what Arnold told us, and you did not disappoint. Thank you.
Thank you.
Norma, I have a question on the delivery services. What's the law on delivery right now? Can they deliver within, you know, there's no sense in delivering within Vernon, but what are the restrictions going outside of the city?
There are no restrictions. So in the past, as city attorneys, we had it wrong. In the past, we would say, if let's say the city of Vernon bans delivery, then let's say if Maywood wanted to deliver into Vernon, then we would say, well, Maywood can't come into the city because the city bans it, right? The state corrected us and said, that's not correct. Like, the idea is that there is no if the state allows for delivery, if let's say someone from another city asks for delivery for the city of Vernon, there is no restriction, and the city cannot provide that restriction. You are required to basically, like any kind of transportation, is that you have to allow your public roads for that purpose, for delivery purposes.
Okay.
Norma, out of curiosity, does the City of Commerce have like a max amount of those allowed to operate?
They don't. In all of the cities that we've reviewed and worked, except, you know, I think currently now there might be a trend, but there has been no maximum set. Again, I think, but although there has no maximum set, we do implement in the ordinance that at any point, should city council decide to, or city administration decide to limit it, that you have the discretion to do so. And again, the reason is that you may have a pool of operators, but then not all of them will operate. So you have a natural digression of naturally some will not be up and running. The other component too that we noticed is that when you do have a cap, the reality is that you are impacting property prices. So you typically have a situation where now landlords, right, are taking advantage that there's only 4, let's say the city is only allowing for 4 operations and there's only 4 vacant buildings. So they're going to take advantage and really increase the price of that now you're impacting all of your city and creating sometimes a problem from, let's say, developers, right? Let's say developers want to come in for housing or for other, now you're creating a not accurate comparables of your price. So that's where, interestingly, in talking to other cities, that was some of their thinking of, it's best not to put maximums, at least in the beginning.
Because then you're going to create like bidding wars to get in. Okay. All right, well, thank you so much. Is there any additional questions for Norma?
No, but I do have a question. Wait, make sure. I do have a question for the chief, our chief Miranda. Chief, can I get some input from you on how you feel about this?
Yes, during some of the initial conversations we've had when this issue came up, I did reach out to several partners, chiefs who have cannabis cultivation in their cities, and they are not reporting any issues with the cannabis cultivation only. There are other cities that have some issues with the dispensary side of it because of the illegal ones popping up around them and creating a whole nother issue. But I don't think we're talking about dispensaries, walk-in retailer like liquor stores for marijuana. So on the cultivation side, I can speak with confidence in the chiefs that I have spoken with that they have not experienced any issues. And it appears to be like any other commercial warehouse in their city.
Thank you, Chief.
Okay, without any further questions, we will now go on to consent calendar.
And just to clarify, is there any specific direction that we should consider at this point?
I'd like to still talk about it if we can. Can we keep it like, I don't know what would be next to do, but I'd like to keep this as an option for the city instead of just receiving and filing.
And I'll defer to Arnold in that regard.
Yes, Mayor and members of the City Council, in that case would be, there was a lot to digest this morning. We recognize that. What we might suggest is we can work with Carlos to set another date coming up in the near future. I know today's agenda is pretty lengthy, but we can set up another date in which to have an opportunity for the City Council to provide specific direction. And so what we would then accept or request at this time is just to continue the matter to a date in the future.
I would agree to that. I would like to do something to move it forward a little bit instead of just tabling it until next time. Is there a compromise that we can achieve perhaps?
Well, Mayor, yeah, I'm not looking to put it too far out in the future. Again, recognizing there's a lot here before you, and a compromise to that would either be to give some direction regarding the ordinance, but I think what's being requested is just to hold it over for another date for further discussion.
Okay.
Well, can you put something together what an ordinance would look like and bring it to the next city council meeting? Based off of everything that was presented and the minimal, everything basically that we just discussed today.
And kind of being a model to what Commerce is doing.
We can start.
If it pleases the council, what we can do is if we can get a motion for option number 1 and we can move forward and bring back additional information to the council with option number 1.
I'll move. I'll second.
Sorry, I was on mute. Not
Yes,
by.
I agree.
Sorry. We have a motion by Councilmember Menke, seconded by Councilmember Gonzalez to direct the city attorney's office in conjunction with city staff to draft a proposed ordinance and bring that back at a future meeting. I'll call the roll. Mayor Lopez?
Yes.
Mayor
Sorry,
Pro Tem-
Lisa, can you add to that?
Sure.
Can we also add like more information on, like if we can put a structure in there on plan checks, how, work with county to see if we can get it in line with our business model, what we're currently doing with current business licenses and everything. And then also, there was something else, hold on. And then probably, see who would take over, who would be in charge of the process? Like, would it be Public Works? I know I have my notes all over the place, so I'm sorry. Public Works, anything like that. Like, how would it affect each department? If we could get some more information on that.
And
So
who
in
would be supporting the individuals that are applying and so forth?
Correct. I want to see a structure, not just the ordinance, but I want to see a structure, a plan, something in place, you know. I want to see what the city can put together with Norma and Arnold on a plan. You know, what does it look like?
So basically it would be to do option number 1 plus what Melissa said, right?
Which looks like probably option number 2.
So 1 and 2 together, is that what we're thinking?
Yeah. Because I want to know how it affects our departments internally. If they're going to need to add, personnel to deal with it. How is it going to start from the beginning to the end? So from the time they apply to the time they get their permit. And then also, how are we looking at it? Our, you know, annual checks, everything. I want to see it all, the plan.
And modeled it very similar to Commerce, correct? Is that what we're
If we could
thinking?
come up with a plan of our own that we can pick and choose from all these other cities, but you know, I want to see what we come up with.
I agree.
So the maker, Councilmember Menke, has approved this friendly amendment. Councilmember Gonzalez, do you as well?
Yes.
So the motion to direct the city attorney's office to draft an ordinance and to bring back with that ordinance additional information on the procedures that will be utilized by the city, including necessary staff, plan checks with LA County, that process, liaisons, et cetera. The citywide plan for how we would implement this. With that, I will call the question. Mayor Lopez,
Yes.
Mayor Pro Tem Ibarra,
Yes.
Councilmember Davis,
He's on mute.
Councilmember Davis, you may need to unmute yourself, please. If I could. We'll come back to Councilmember Davis. Councilmember Menke,
Yes.
Councilmember Gonzalez,
Yes.
and it looks like he's summoning assistance. Councilmember Davis, do you see the unmute button?
Okay,
There we go. We would like your vote on the motion to direct the city attorney's office to bring back an ordinance along with a citywide plan for implementation.
yes,
Thank you. Motion carries.
Thank you. We will now go on to the consent calendar. All matters listed on the consent calendar are to be approved with one motion. Items may be removed from the consent calendar by any member of the council. Those items removed will be considered immediately after the consent calendar. Does council wish to pull any items from the consent calendar?
Yes, I would like to pull item number 12.
Okay. So may I have a motion for consent calendar item numbers 4 through 11 and 13?
So
moved.
moved.
I'll second.
If I can just check, are there any attendees wishing to speak? Mike? No. So a motion by Councilmember Menke, seconded by Mayor Pro Tem Ibarra, I believe. Is that correct? To approve the consent calendar with the exception of item number 12. I'll call the roll. Mayor Lopez,
Yes.
Mayor Pro Tem Ibarra,
Yes.
Councilmember Davis,
yes,
Councilmember Menke,
Yes.
Councilmember Gonzalez.
Yes.
Motion carries. So
Okay, now
item
for
number,
item number 12.
item number 12 is office lease agreement with the Vernon Chamber of Commerce. And Finance Director Williams will respond to any questions you may have.
Okay, so I was looking at this item number 12, And I was very concerned with the fact that here the chamber is in this building of ours, where I've been told by Maritza herself, I've heard it from Carlos, I've heard it from my father-in-law stories, how it has a lot of asbestos. And I would like to have some expert come in and evaluate it, and see exactly how bad the problem is. I mean, I understand that we know, we're all aware. I know the chamber and everybody there is all aware. We know that they know that there is a problem and it's in the contract. And even though they signed and everything, if anybody gets ill, they could still turn around and sue us. Am I correct, Arno?
Well, to answer the question, Mayor and Council, anybody subject to lawsuit, the answer is yes. I'm not sure of the specifics, but the answer to the question is yes. The city is always.
This is Dan Wall, if I may address the question. So there has already been a lead and asbestos study of the building, and the office spaces that are currently used both by the chamber and by our gas division do not have lead or asbestos contamination in them.
Okay, so can I request that information just to be safe, make sure that there's no liability for the city, and if so, how much would it be to clean it up just in the area that they're in or around?
Yes, we'll get those records and provide them through the city administrator's office.
I'm just concerned for their safety. Being that
Chambers on a month-to-month right now, so it wouldn't impact them, correct?
It's month to month right now. What is for the council's consideration is for this to actually become a 12-month lease since the previous one expired. So they're fine for now. This is delayed slightly, but I would also add that I had this discussion with Dan previously regarding the condition of the building, and this is what actually suits it for office space rental only. It's really because of the lead paint, base paint in particular. It's not suitable for what it would normally be used for industrial or warehouse purposes. So this benefits the city as it wouldn't normally be rented out, and it provides both security and a small amount of revenue.
My question would be, I've seen that big space in the back, and if that's where the lead-based paint is and perhaps asbestos, isn't that, I mean, doesn't it move through the air and potentially go through the HVAC system?
So that you are right. There is an unutilized warehouse space in the back, and that is where the lead contamination is. That area is not air conditioned, and so the likelihood of stuff being transmitted through the HVAC, I just don't see that as being an issue.
Well, then how about the air? Because we know from Exide, experience with Exide, that it goes through the air.
And I remember coming into that office and Maritza pointing that out to me. That's why I'm bringing it up. One of the reasons why I'm bringing it up.
Yes, we will provide the report for your review.
Thank you.
Is the chamber in agreement with extending their lease?
They are requesting it back.
Okay, so they signed off on a waiver, or how does that work
Well,
out?
it just based on the stipulation, it just goes to month, but they're they actually brought this to our attention some months back that it was coming up and requesting the lease. So,
Is there an issue if we approve the lease or go to vote on the lease and then issue, discuss the building after on our next meeting?
I
It
think
could go anywhere, Arnold, Scott, you know.
I think that's
admin.
for the council.
If
I
the
mean-
chamber is in agreement and was already on a lease, then, I mean, they're in knowledge of the issue, right?
How long have they leased the building for?
It's been years. I mean, the last records I have go back a couple of years. Prior to that, 2018, May 2018.
They're going on the third year.
You can't waive personal injury, can you, Arnold? I mean, they could sue us regardless.
They could. I mean, the chamber, the chamber is contractually, you cannot limit your personal injury claims. You have a right to limit your contractual claims. But
But besides that, we don't want anybody to occupy a building if it's a danger to themselves, even if they sign off on it.
Yeah, I mean, they can accept the premises as is, which we could add that to the contract.
I believe that because we do have city staff that is also housed at that building, and we do have the warehousing capability on the far west side of the building. So there's 4 different compartments of the building. One of them, which we are talking about, is a vacant warehouse where it does have lead paint, and we have had it tested, and we are aware of the issue. The other sections are clear, and we do have city staff. Our gas department, DPU, utilizes the same office space in the same vicinity with the chamber. It is my understanding, and Dan, please correct me if I'm wrong, we have guidance from professionals to is safe in that building, and that they did do testing, and we found no issues in the office space. Is that correct, Dan?
Yes, Carlos, that's correct. The only place where we found lead paint contamination is in the unused warehouse, which is sectioned off from the rest of the uses.
But they do have the ability to go in there. I mean, because I've been in there myself, so.
One of the things that we can do is seek bids to go ahead and clean up the area of the warehousing that does have the lead paint. I think the estimates that we received were north of $100,000. Dan, is that correct?
Yes, that is correct. So there is that cost, and it's, I guess, a question of whether we do it now or do it later, because ultimately, whatever the use is for that building, if we ever intend to use that back space, or if we intend to demolish the building, it's going to require lead paint remediation.
So if we did utilize it as a warehouse, the income would increase substantially, am I correct?
Well, Councilmember Menke, if we did utilize it as a warehouse, it would be for city-owned use at this time, as we do have requirements for additional warehouse space. But we are utilizing the 2 other sections of that warehouse currently, and I believe that the fire department and used to use their facility to store some of their fire engines and so forth. And we did have the computer lab mobile truck that was stored there at that site too. And then the gas department has a complete warehouse that is used currently for all their inventory items on the far west side.
Thank you.
We would have to move the current employees from the city, right, that are occupying. I mean, if
No.
the chamber can occupy it, then no one should, right?
No, we currently we're okay where we're operating to utilize the office space. The warehouse is what's the issue is the warehouse requires additional cleanup for the lead paint that is actually in that facility. So the other areas of that building have been cleared for occupancy.
So if the gas employees for the city are housed there, then I would assume that it's also safe for the chamber to continue to be there, right? Why is it okay for the, gas employees to remain there, however, not the chamber?
Dan,
Doesn't really make sense.
no, the studies have already indicated that it is safe for occupancy, correct, Dan?
Yes, that is correct.
And we will share that with city council and our city attorney as well.
I would
Go
like to
ahead,
see
Dan.
that.
Dan, go ahead.
Oh, I was just going to say, we do have the lead and asbestos survey that was conducted there. Lead was only identified in the one unused part of the building, and there were no recommendations to remove occupants from the parts of the building that were not contaminated.
When was that done, Dan?
That was done about 2 years ago.
So that's still pretty, that's pretty recent, right?
Yes, yeah.
And I think
Is
the other
it
thing,
recommended, how often is it recommended that be done?
Well, there shouldn't be any change in the conditions that are there as far as lead paint goes. We're not using lead paint now, and so the lead paint that's there is there until we remove it.
and I think the definition there is if it's left undisturbed, the lead in the paint and the asbestos and building components are not hazardous, as long as they are not disturbed.
Yes, yeah.
I've heard that too before.
Yeah, and yeah, if it would provide comfort, we could make sure that any access from the office space is sealed up to prevent people from wandering into that warehouse.
Since it's not going to inconvenience the chamber at all, they're on a month to month. They're not facing eviction. We're just trying to make sure they're safe. What I would propose is that Arnold look at the information that Dan's going to provide and just make sure that it's all good. I feel better about it.
Hey, I have a question. If I remember this, I have to remember 3 years back and it's kind of hard. Didn't the chamber sign a letter indemnifying the city of anything just because of the asbestos stuff?
That is correct. The chamber did sign an indemnification and holding the city harmless.
And based off of Carol's concern, would we, Arnold, I think this is a question for you legally, would we be liable for it?
If somebody is too false ill?
There's two issues. One is a waiver and the second is indemnification. The chamber would need to indemnify the city or provide an indemnification agreement with the city that in the event of any lawsuit by any guest or employee of the chamber, that they would indemnify the city with their insurance.
And Arnold, we could forward that to your office, but I believe they did sign that.
Okay, that'd be great.
But does that answer Carol's concern?
No, because this is the first time I'm hearing about an indemnification agreement. All I want to do is just bring it back next time because they're there, they're paying rent, everything's good. And have Arnold review the documents and make sure we're in a good position. That's all.
I do want to mention that I believe this is addressed on page 14 of the agreement.
I looked at that, Scott. Let me pull that back up. There is indemnification language in the lease itself, paragraph 40. But is there a separate indemnification agreement from the chamber?
I don't know. Yeah, we'll go back and get detail on that.
And then also with I think what would be a good idea, Mayor and Council, would be the report that Dan has, that we provide that report to the chamber, have them acknowledge that they've received it in full disclosure, and then also waive, provide indemnification, waive any responsibility of the city.
That sounds reasonable.
Mhm.
Okay, so we'll bring it back at next meeting with that information.
Yes, we'll
Is there a
agendize it for the next, we'll agendize it for the next meeting and bring back the information.
Perfect. Thank you.
Thank you.
We will now go on to new business, item number 14.
Item 14 is the municipal code cleanup, and I will present the report.
Can I be
Sweeping
heard
work-
before you start, please, Ms. Clerk?
I'm sorry?
Can I be heard just for a moment? Before you begin your presentation, because it's going to be lengthy, and I just have a few housekeeping issues. Can I comment?
If the mayor is fine with that, I'm okay with that.
Go ahead.
Thank you. First of all, I appreciate the amount of work that you put into this endeavor. It's incredible. And that's a good thing and a bad thing, because I know you said that the hard part's going to come later. Well, this was hard for me to review, and I don't believe I've had enough time to adequately review these sweeping changes. When I was thinking about cleaning up the code, I was thinking about language cleanup, whether the laws were in conflict between the state and us. I really didn't think we were going to go to this extent, which includes repealing certain code sections. I would like to see this done like we eat an elephant, one bite at a time. And perhaps we could put off the first reading and ask it to be presented in smaller segments, and perhaps the city attorney could give an opinion on the relevant portions proposed. Because for me, I know I haven't had enough time to review this. And these are really important changes, and it's policy changes. That's all I have to say.
With that, Mayor, if it's your pleasure, I will proceed with my presentation.
Yes, please. Go ahead.
We are currently in the process of recodifying our code with a new codification company. During that process, conflicts, inconsistencies, preemptions, inaccuracies, and duplications in city regulations and between state and federal statutes will be identified. The cost of this recodification is based strictly on the number of pages that are transitioned from the current code to the new code. In looking at our code, there are many provisions that are outdated, no longer apply to the way the city conducts business, and are in conflict with state and federal laws. So this is just a starting point based on the low-hanging fruit, the items that staff has consistently brought to my attention or brings up as outdated, inconsistent with state law. So as the report indicates, we will bring back changes determined through the recodification process, as well as the more complex issues in the utility procedures and in zoning revisions that may come up during the West Side specific plan process. There are several revisions outlined in the report. If it's the council's desire, I will go through each of the proposed revisions, or I'd be happy to respond to specific questions that you may have about the revisions. As indicated, they are cleanup provisions, best practices to reflect state law, federal law, and outdated city practices. So whichever the council desires, please let me know.
I have a question. Was it Quality Code Publishing who recommended these changes?
No, these are changes that city staff brought to my attention, or that I, in using the code for the past year, noticed issues with.
Okay. I would like to see it gone through one item at a time. But I have probably 10 pages of notes for questions on each of the sections. So whichever way you want to do it, it's okay with me.
The remainder of the council like for me to go through each section at a time, or would you like me to respond to specific questions?
Just specific questions if you wanted to.
What is the consensus? Mayor Pro Tem Ibarra,
I'm okay with specific questions.
Mhm.
Councilmember Gonzalez,
There's a lot of it that I don't understand.
okay, so we'll just do specific questions and I guess that's the consensus.
Mhm.
Okay, well, I guess I have the questions then. Well, to begin with, I know that you said this is an ongoing process, but we're being asked to make an ordinance that actually repeals some of the sections, et cetera, right? I want to just make sure that I'm clear.
I'm sorry, we were having technical difficulties here. Can you please repeat that question?
Okay. I know you said it's an ongoing process, but for the sections that are set forth today, you're asking us to amend or repeal these sections pursuant to ordinance, correct?
Yes.
Okay, so we'll start with section 1, which has to do with increasing the penalty for safety and building code violations. I looked at the government code section. I've looked at other cities, and because it's an infraction, I'm not sure, and I'm going to have to look to guidance of council for this, that we can appropriately increase those fees. to that
Carol,
amount.
Carol, sorry, can I make a request? When you start asking the question, can you refer to what chapter and what code section, just so that
Sure.
I can follow?
Absolutely. It's section 1.
Of the ordinance, section
Of
1
the
of the
ordinance.
ordinance.
That's
1.8E, right?
1.9.
1.8E.
Mhm.
Okay. Thank you.
So did you hear my question?
I believe you asked for legal advice on whether or not those fees could be increased, being that it's an infraction.
That's correct.
I'll
So
defer to.
Arnold, it's in your court now.
The changes in the, I'm pulling up the code, the changes in the proposed ordinance address increases to the fines available. We are, I mean, the fines that are in our code are certainly low, very low. My recollection is that as it relates to code enforcement penalties, that they are able to be now on a sliding scale. And for first, second, and third infractions, I believe that those are the appropriate numbers in the now set forth in the government code. Now, we are a charter city, and we can establish whatever standards we wish to apply. So those numbers are at the discretion of the city council.
And I apologize. It looks like I caught you off guard too. Have you had enough time to review this and give an opinion as we go along on these sections?
I should be able to. I mean, there are some specifics that if the council has questions that I haven't specifically researched, I would probably raise that and say, let's bring that section back. But I have worked through the proposed code changes, yes.
Okay.
If I
Because
could just point out, the proposed modification is to section 1.8E. And the section just above that 1.8D refers to infractions, and it lists the specific dollar amounts for infractions. So this section is just related to building and safety code violations.
I beg to differ with you. Section E says, notwithstanding any other provision of the law, a violation of local building code and safety codes determined to be an infraction is punishable by.
1.8.
And we are allowed to provide specific fines associated with that infraction.
See, this is where I mean, nobody's giving me any authority that we can raise them, or should we raise them? Is this business friendly? I mean, I
Arnold-
look at others.
Arnold Arnold stated that we can, that it's the discretion of the council, right? Isn't
And I
that what
would-
you stated, Arnold?
I wouldn't have an issue with that, just for the simple reason that these are infractions. These are violations by these businesses, and it keeps them in line. And any other city, if you're going to compare to any other city, I'm pretty sure they're in line to this.
Yeah,
You know, our
$100 and
fees,
fine.
our fees,
Yeah.
our fees are different than infractions. Our free, we want to be business friendly on
Exactly.
fees. But infractions, I think we have the safety of our community to keep in mind. You know, if we're going to be charging, you know, a business $100, they'd rather pay the $100 fee than fix the issue. You know,
Well,
and
and
for
if-
me, I think these fees are in line, not in line, but I think these fees are reasonable.
I
It keeps
agree.
them and avoids them from further issues.
Also, if I may address the council, this is Dan. So when there is a violation of the building code, Public Works meets with the business operator and goes through education. We put them on a timetable to make the correction. We contact the property owner to see if pressure can be exerted that way. These fines are absolutely our last resort. And so at $100, as Councilmember Ibarra stated, that's just the cost of doing business for people who are determined to continue to violate the code. And so by raising them to these levels, it gets the attention of business operators that the city is serious in enforcing the code.
I mean,
If
my
I could
question
just-
is.
I'm
is
sorry,
basic.
I could just remind everyone, if you are not speaking, please mute your microphone. Thank you.
Basically, it's just this. I looked at the county, I looked at the government code, I looked at the city of Santa Monica, and I looked at the city of Paramount. My question is, because these are infractions, which are penalties, is there a different standard? Do we have to go by state law? That's my question.
If I may weigh in, Mayor?
Yes, please.
And I looked at the full code as currently crafted. And the code, the city code currently provides in section 1.8A misdemeanors, and consistent with the penal code, our maximum fine for misdemeanors crimes is $1,000, or imprisonment in the county jail for not more than 6 months, or both fine and imprisonment. That's for misdemeanors. Then the B provides that it really doesn't apply. We jump down to D, infractions, and then E, which is the subject of this conversation. And an infraction is generally a much lower level crime. But what we're talking about here is the provisions of violations of our building code and code enforcement actions. So those are more administrative fines than they are criminal penalty fines. Pull that up. Again, because we are a charter city, the city council has the discretion to establish those fines at the levels that you feel are appropriate. Now, if they are too high, the council can. Let me pull that language again. I believe it says. I'm sorry. I'm bouncing back and forth on my computer to the agenda report and the municipal code that we have. There we go. Okay. And yes, the language that's proposed is not exceeding. So it can be anywhere from, the first violation can be anywhere from $0 to $1,000. The second violation, again, can be $0 to $5,000. And a third violation for violations of our building and safety codes can be from $0 to $10,000. And that is, and those are primarily administrative assessments that are in the form of a fine based upon an infraction. So again, I'm not looking to weigh in into the policy aspect of the council, but does the council have the ability to set those infraction levels at whatever level you wish to? The answer to that would be yes.
And I just, one more question. You mentioned that misdemeanors were set at $1,000. Isn't that pursuant to the bail code, the Uniform Bail Code? And I agree, and I certainly, we're a charter city and I want to stay that way. However, we can only give more benefits to our citizens. We can't give less, or that would be unconstitutional, correct? So I'm just asking, are we preempted from doing this because of state law?
Mayor and council, my response to that, Councilmember Menke, would be the city council would not be preempted by state law in this area. The city has again, we're talking two different apples and oranges. The criminal penalty for misdemeanors is generally established by the penal code. And that's generally for misdemeanors of $1,000 limit. These are administrative, they are violations of our building and safety code and our code enforcement process. And those generally can be established by the local jurisdiction and as a charter city, it would be my view that we can set whatever amounts you want. So, council member, if you feel that those numbers are too high, you can propose lower numbers. You can propose higher numbers if you wish. So
That wasn't really my question. It was the appropriateness of.
yeah.
I think Arnold already stated that it is appropriate, that we can set, and this is not a penal or a criminal violation. This is for local building and safety codes, right? And honestly, an infraction for traffic save, if you're speeding, is almost $500 for a private citizen. So I feel that that's pretty reasonable. So can we go on to the next question as it's been answered, right?
Okay, so we're moving on to section, now, again, I'm referring to the ordinance, section 2, sections 1.9, 1.91 et al. This repeals the newspaper that the city utilizes for publication of any ordinance, for any public hearings.
It actually doesn't repeal the newspaper. What it does is it repeals the fact that we're stating in our code which newspaper we're utilizing. And the issue with that is that it should effectively be sent out to RFP every 3 years, and therefore we'd have to come back with a new ordinance if that newspaper changed. So I'm just saying, let's not list the name of the company in our code.
But we're repealing all of those and replacing it with state law, I believe it says, but I don't see a copy of that.
State law requires us to publish various hearings with specific dates prior to the hearing. It also requires us to publish ordinances or their summaries after they're introduced and adopted. And so those are the provisions we would be following. I'm not at all saying let's not continue with our publication efforts. I'm just saying, let's not list the Los Angeles Wave or whatever company it is that we use here, because we're going to go out to RFP every 3 years. And we'd have to bring an ordinance back if that company changed. And as
And
far as section, I'm sorry.
Go ahead. No, go ahead.
As far as section 1.91, I'm sorry, that was 1.9 I was referring to. 1.91, we'd still be publishing the ordinances as we do now, reflective of state law, which requires that the summary be posted after introduction and again after adoption. And we do that in a adjudicated newspaper of general circulation within the city. 1.93, it just restates that we're going to follow state law. So that's redundant with state law. And then 1.10 provided the opportunity that if we failed to meet the legal requirements for publishing, that we had some other alternatives of posting, which I find troubling and not within our best practices for transparency. So I'm suggesting that that section be deleted.
So you don't think posting is an acceptable or a best practice?
Not if we missed the legally required publishing requirements. I don't think you then say, oh, well, we'll just stick it on a bulletin board on the corner of 2 streets within the city. That doesn't seem very transparent. I would prefer to follow the state laws and do what we're supposed to in the best interest of the public.
And then again, the one thing I am concerned about overall is we are a charter city, and we keep every section, or almost every section I've noticed, we are following some government code or some state law section. That's the difference between a general law city and a charter city. And I just want to make sure that, you know, it's a slippery slope, not because somebody crafted all of these sections very carefully. And just to take on what state law says isn't necessarily always a good thing. Being a charter city ensured that we could do things the way we wanted to do them to a certain extent. So that
Councilmember, that is true, but I think that these provisions regarding publication were crafted prior to the good governance reform, and I think that it would be best practice to follow the more restrictive state laws.
And I think these conversations are the things we need to have.
Excellent.
So
that
answers my question. I disagree, but respectfully, but I think it's important that we have this discourse, and it's going to be painful. Now moving on to section 3, section 2.2. And this is the thing that bothered me. I get about the bond requirement, and you're taking the city administrator and putting it all into one, and I agree with all that. That's sufficient. However, we don't have a bond amount now that's been stricken. I would suggest that we use the language that was in the city administrator's bond requirement that says, okay, this is the language I suggest. The city administrator, city clerk, deputy of finance, city treasurer, and their deputies and/or, if any, shall before entering upon their duties of their office, give a good and sufficient surety bond to the city in such amount and form as shall be approved by the city attorney. I think we need some oversight because there is no bond amount.
The government code section does specify that the city council can approve those bond amounts by resolution. And I think that is more adequate oversight than having an employee of the city make that determination. So a resolution will be brought back to you if this section was changed to specify the amounts that the city council would like those bonds to be in.
So what would the bond amounts be at the present time?
when that resolution comes back to the council, I would conduct the research and make sure that their adequate amounts is specified by the government code.
So right now, if we change this, what would be your bond amount? Personal.
No less than is currently specified in our code, but I'd have to look at the government code requirements, and it's at the discretion of the city council to establish those amounts.
So shouldn't we be establishing those amounts now, since we're deferring to the government code?
If I may be candid, there currently are no bonds for the top officials in the city. So I think that bringing back a resolution and allowing the council to determine those amounts would be appropriate in the very near future.
First of all, that's disturbing. And that even gives me more reason to insist that we craft this so that we have more assurance that you're going to have bonds, because there's a lot of money in the city.
If you'd like to revise the language to include specific amounts, I don't see an issue with putting it in the ordinance. Other than that, if the city council desires to increase those, we'd have to bring it back by ordinance, which is fine.
Lisa, real quick question. Sorry, Carol.
Go ahead.
On section 2.2, oh my God, I completely went blank. Sorry. Section 2.2, can we pull this out and discuss it later, or is this something that's going to go in effect right away?
It would be effective upon the adoption of the ordinance. I think that Councilmember Menke's concern is that there's no specific amounts listed. I think that we could say, sorry, wordsmithing on the fly is sometimes difficult. So section 2.2A says that the city administrator, city clerk, director of finance, and city treasurer are each required to execute an official bond in such amount as may be reasonably required by city council resolution. So you could say in the following amounts, required to execute an official bond in the following amounts, and then list those as indicated previously, Councilmember Menke, which has city treasurer and city clerk at $50,000. Deputy city clerks and deputy treasurers would not be required to file bonds, but we could make the city administrator and director of finance at whatever levels you find fit.
I'm not sure I know what levels are appropriate. That's out of my wheelhouse. But as long as it's the important characters and it's the highest amount that's already in the code, I don't think I can ask for more than that.
So if I could provide a recommendation off the cuff. So the following amounts: city administrator, $100,000, city clerk. You can make them all $100,000, all $50,000, whatever you find appropriate.
All 100,000 would be good for me.
And in between this meeting and when this ordinance comes back, I will clarify the language on that section. I will also provide you with bonds that other cities, or maybe Arnold has that information handy. We just need to look at their codes and see what their statute says. But if
as I said, this is a lot, and I have a lot of questions, and I'm sorry, but I think it's important that they be asked. And I appreciate your helping me with this. And I think that would be perfect.
Okay, so we'll amend that section to reflect the specific amount of $100,000 for each of the 4 positions listed there.
Okay, on to section 4, which is section 4 of the proposed ordinance. And that's section 2.5-5. It repeals all of the sections and going through actually, well, we'll start with the first one. Is the finance committee and personnel committee defunct? Are they really? Or when we look at the budget and when we do personnel issues, don't we wear that hat? Or is it really an old fashioned kind of a thing?
As far as back as since Lily's been here at least 4 or 5 years, the committees have not met. If the
Arnold?
council at any time wanted to establish a finance committee of the city council or personnel committee, it could do that, but they're currently not meeting and they're not in existence, so.
What I'm trying to say is, I think when the budget is, well, let's say this is where I believe I saw this, the audit, when we look at the audit, aren't we acting then as the finance committee, Arnold?
Council, when it comes to the entire council, this would be a subcommittee of the council generally.
No, there's all 5 members.
I'm sorry?
It's all 5 members. It's not a subcommittee. All 5 members of the council act as the finance committee and the personnel committee.
Well, we have not had those meetings since I've been here.
I'm just saying we switch hats. So Scott, can you speak on this?
So in my experience, it's that we do state that the 5 members in ours, but in my experience, it's been a subset of the council because or typically just a maximum of 2 members, but it's also been in cities where you had an elected treasurer, which really the position is a formality. So you mentioned something that's just kind of had a little more functionality to it in the past. The purpose of the committee is really to have the discussions outside. They're noticed meetings, but to have discussions which are always available to the council through city administrator if there are specifics, and those can be helpful, like if we're going out to RFP or an auditor, or if there's questions regarding the audit. But functionally, so for instance, we're planning in a couple of weeks to bring the audited financial results, and we will have the auditor make that presentation, and it's what they call the SAS 114, and that's the full transparency and presentation to the council if there are any findings, any concerns, and then of course that opportunity to ask any questions.
And that's presented to the entire council, is that correct?
It is.
So do we need a personnel committee and a finance committee? That's, I guess, my bottom line question.
Okay.
It just adds a layer.
We do not. This is based on discussions I had with staff, Michael Earl in HR and Scott in finance. We don't need these 2 committees, which is why I've recommended that they be removed, or why staff recommended.
Arnold, are you on board with that?
Yes.
Okay, all right. And Scott, you were saying, I think were interrupted, but.
Just really, it adds a layer to the decision making because the council has the same thing available to all of you, and it involves all of you, and to have these types of discussions if necessary. So if something were extensive enough, it could be in a workshop format like we do with the budget, and we have multiple workshop meetings to get us to a final work product.
You're okay with repealing that section?
I am, yes.
Okay, thank you. Moving on. And we already spoke on section 7 of the ordinance, section 2.6-4 of the code, repealing the bond requirement for the city administrator. So we don't have to speak on that any further. Yay. We'll go to, because that's going to be repealed, right? And added into the other section.
Correct.
Okay. Section 8, which is code section 2.61. I know nothing about the RDA and successor agencies, so I just need a little education on that.
So this was actually, even though it's not my section, it's my item. So previously, redevelopment in California, this was where blighted areas, we were able to come in and declare an impact area. Is a very helpful tool for economic development. But it was long overdue, just because some of the excesses that you could read about in the history of RDA. There were cities like ours that greatly benefited from the right use of it. So it allowed so you set up an RDA agency, issued bonds, and you're able to make to partner with developers making much needed improvements. Sometimes it was a widening of the street. Sometimes it's a much more comprehensive, like environmental. So that ended in 2012, and we really just became the success. Each city had the option of becoming the successor of the redevelopment agency, and that's what took place. And we're really at the sunset stage. There's approximately $42 million in bonds outstanding for our RDA, but that is paid for entirely from what we call property tax increments. In other words, that's distributed to us 100% to service that debt. Plus, we're given $250,000 administrative fees just to cover our staff time and things of that nature. So that's where we're at. It is winding down. We are this year. We're actually planning to issue what's called the last and final recognized obligation payment schedule, or you hear that term ROPS. And so that at that point, there will be no more reports to the county oversight board, and this will be brought to council in 2 weeks at the next meeting, but you'll see that. And then that truly sunsets it. So it's really just a recognition that RDA hasn't existed for 9 years, and it's time to just call it successor agency. We only
Thank you. So you're okay with that? It's good. And it is your item, so I get it.
Councilmember Menke, if I could just clarify that each of these items were either brought to me by the various departments. So Scott brought this section for revision. Therefore, he approved it. It wasn't just me coming up with some of these things.
And I know you're bright, but I really, this is a lot of work, and I'm certain of that, but that doesn't minimize the questions that I have, unfortunately. I was going to ask, do we need a break, guys, for 5 minutes, or do you want to continue? Because I've probably got 5 more pages to go.
What is the consensus of the council? Do you guys want to push through or 5-minute break?
I could use 5-minute break.
Yeah, I can use a 5-minute break.
Okay, let's take a 5-minute break.
Thank you.
We'll come back.
Okay, thanks.
Mayor, it looks like everyone's back in the room.
Okay, I think it's safe to continue.
Carol, I think you're muted.
Was muted all the time. Okay, now we're at section 9, chapter 2, article 10, section 2.69-1, which removes city council department and places it under admin. In your staff report, it states that this section references a city council department, which is technically support by city admin and should be combined with such. I respectfully disagree and think they should remain separate and distinct. So if somebody wants to comment on that.
I'm okay with removing that and keeping council on its own. Just leave it as, you know, as its own head.
So are you saying keep that department in the list of departments?
Correct.
As its own department. Even though we're supported by admin and, you know, everything's through admin, I think council should be considered its own department.
Is there a third?
I
vote
agree.
Okay, so we'll leave section C 2.69-1C as is.
Perfect. So now moving on to the Director of Health and Environmental Control. We're taking out that he also serves as the city health officer, which is fine. But later on in the code, the city health officer is mentioned, and that see section 28 is what my notes say. So I just think those things have to be in line. We can't get rid of that, but have them, I think it was giving a permit or whatever.
Right. And those will be cleaned up when we do the recodification. You may have noticed that the city clerk is responsible for pretty much everything that happens in the city. And I don't want all those responsibilities, but I think they were written at the time that the city administrator held the title of city clerk. And so those types of things will be cleaned up when we do our full recodification. But thank you for pointing that out. I will make note that's to look at section 28 and all other sections.
And just, this is for your knowledge also, we're removing the Industrial Development Department, which I don't have a problem with. But we have not removed the Industrial Development Department's fund.
And we will look into whether that fund should be removed as well. Like I said, this is the initial starting point, and these types of things we'll do a full search to make sure everything's consistent.
Of course, I'd prefer it all be done at the same time, but I'll leave that up to my colleagues to agree or not. We're removing the office of the treasurer. However, our charter only identifies the office of the city treasurer. So that's inconsistent with our charter. And I'm not sure we can accomplish that.
Section C of this same section does refer to the finance director / city treasurer. That's as it currently exists. So there's no modification there. We were just saying, let's not separately spell it out in its own section because it's redundant.
It needs to be finance / treasury, right?
We currently have the finance department, which says the finance director / city treasurer shall administer the finance department and issues concerning the department. That's how it currently reads. So this was just duplicative.
Okay. We'll move on to section 10. Chapter 2, Article 12. And this is, first of all of these codes were enacted as a part of good governance. This virtually guts all of those. We don't have jurisdiction over recalls or the contests. And this wasn't just done for that election. If you would refer to, which isn't included, section 2.91, it sets forth the purpose of these provisions, which is to eliminate the possibility of corruption. So all that's left, we will repeal everything and be subject to the California election laws. And the only small portion that we've left is something to do with the campaign contributions and definitions, which is now left to be explained by state law. So I have a real concern about eliminating these sections because a lot of thought was gone into these and may be needed in order to get rid of, to prevent corruption in the future. I mean, I'd like to say we're doing everything right now and we don't need it anymore, but that's why it was put there. So can I have some feedback on that, please?
Councilmember, as you know, the city is always free to enact its own election provisions. State law provisions come with the benefit of being well vetted by court decisions. They also offer a kind of uniformity because they're applicable to all general law cities, as well as charter cities that have adopted them. Because these provisions can be sensitive topics for current office holders, election contests or recalls, adoption of state law often puts it does put the council beyond reproach. State law provisions are designed to create a meaningful check and balance on the elected officials, but also impose fair process for all those involved. I think that the provisions that are currently in our code might not be fair and equitable to the voters. And I think that it puts the election contest provisions in the hands of the city council, which best practice would be to follow the law of the state of California and have a court decide on election contests.
You see, at that time, we had a reform monitor and some very high-powered law firms. We are a charter city. We are not a general law city, and I don't want to become one because we lose local control. And I think that's what's happening here, in my humble opinion. Melissa, you were, definitely here when all this was going on. Diana, you also. So I'd like some feedback. Do you think this is appropriate?
I think it's fine. Yeah, go ahead, Lisa.
If I may provide historical reference, the amendments to the code related to recall elections were adopted by the City Council October 2009. They make it far more difficult for the citizen to recall. The provisions are much greater than state law. The campaign finance section was also adopted in December 2009. And the procedures for election contests were adopted June 2012, and that was specifically in regard to the June 5th, 2012 special municipal election. So while I value the city's position as a charter city, as I said, we can always enact our own election provisions, but I feel like these came at a time when they were implemented for a specific purpose, and would be best practice to follow the laws of the state of California.
These were all part of our good governance reform, I believe. And I have every document here except for our code section. I just think these principles are part of the cornerstone of our good governance reforms. And if they're more restrictive, then they are. And that's my opinion.
Carol, you asked for my opinion. My opinion is if we're going towards state law, I don't see an issue with it. There wasn't, deleting a lot of the stuff and cleaning it up. I think they did a good job on. I think we still have the authority to do everything that it's asking for. I'm reading it again right now, and it's just cleaning it up. A lot of this was adopted before the reforms were even put together. And cleaning it up, I don't see an issue with it. As long as it's aligned with the state, it's election. I think the people should have that right.
And just to be absolutely clear, because I don't know the answer to this, if we adopt the California Elections Code, do we have to adopt their election schedule?
No, the provision regarding us allowing us to have our own election schedule has been retained so that we can have our general municipal elections every year in April. I would also like to mention that the city of Vernon is one of the only, if not the only city with these special provisions related to the elections. Every charter city in LA County, with the exception, I think, of Alhambra and the city of LA, follow the laws of the state of California.
And then I'll just say that Vernon, as we all know, is a very unique and different city. So I wouldn't expect us to be like the rest of the cities.
Yeah, we were unique and those were put in place for reasons.
I think it's healthier to stick and coincide
It's
with
'cause we-
state law.
But it's just that because we had such a small population in our city.
But this doesn't, it's giving the population the control. It's removing it from the city. You're going by state law, not city law.
And we have added housing in between all of that. So now we do have more constituents at this point, and our plan obviously is to gain even more. So I think it's safe to say that it is healthy just to go ahead and go with and coincide with state law.
It makes it non-biased and transparent and easy. Keep it in line.
Yeah, easy is, I think, the crux of it. And you have to be, that's a slippery slope, guys. It really
Then at
is.
that point it comes up, we put all these implements in place in the last 10 years, and I think it's healthy,
I feel it's healthy just to have the right amount of people sign a piece of paper. for
And we
any
have that
vote.
right amount of people, we're in the process of increasing our residential once yet again. So
But why
all of
can't we
this
just
will,
keep it that way?
all of this will grow along with our residential population. It's not restricting it. I think it's healthy and it's transparent.
As long as you know what's at stake, then I've done my part. So, of course, it's going to be the majority of us that make this decision, but I think it's important we talk about it.
How about when we increase the population, then we could change it then? It would make more sense, wouldn't it?
Then at that point, you change it again.
That's what I'm saying.
Then at that point, you change it again. As of right now, I think this coincides with cleaning up everything that's happened. Lisa was tasked, our city clerk was tasked with this, and I guess she's done a major review of it over the years, and each department chipped in. I think these are the major ones they've been looking at for a long time. I don't see an issue. It makes it non-biased and it makes it transparent, and it gives the people the vote.
And each department has put their input, and they deal with this on a daily basis, so they know what is needed, what needs to be removed, what's outdated. And
With
they
all
deal
due
with
respect,
all of this
Mayor,
all the time.
this is our final decision. This is our legacy that we'll be leaving behind. That's why it's important. I agree, we have the greatest people as department heads, but it's still incumbent upon us to do our job.
And remember, when we term out, we still have a voice here. We live here. So
Of
if you're
course.
not active at that point, then that's on you.
Oh, you
For
know,
us,
me, I've
we're
never-
doing, but for us right now, what we're doing is we're doing our job.
I just want to make sure that, everything, I can't just rely on the fact that we have good people in high places and just say they'll take care of it. I need to ask the questions that bother me, and I hope they bother you too, to a certain extent.
Coinciding with California code doesn't bother me. I think that it's moving in the right direction at this point. We'll see
Just-
what happens, later down the line, if it doesn't at that time anymore. But I think at this point, I think it does.
Just remember what I'm saying. Just be careful when we start giving over our power as a city, as a charter city, to state or federal government, we are giving up local control, which is something we fight for all the time.
But I don't see how we're doing that right now when we're just cleaning up some items. It's not like we're cleaning up the whole thing, that we're gonna go state and federal. We're aligning ourselves, that we're aligning it. We're right now, I think the way our codes are set up is we're aligned, but we're like far out. Our branches are forked out so much. We're trying to bring it all back together and clean it up. You have decades of stuff that needs to be revised, and they were revised under stressful events, or before reform, after reform, and it contradicts one another. I think
I agree
staff
with
did a
you.
good time, and I think staff did a good time on going through them one by one over the years and trying to clean it up. And it's good that we do this all at once, rather than some right now and then a few months later revise it, and then a few months later, oh, it didn't work, so let's revise it again. I think this is healthy, and this is a healthy dialogue. Thank you.
I agree with you absolutely 100%. I
But
just
I
want
don't
to be sure you hear me. That's all.
Oh yeah, we hear you.
Okay. You may not like it, but hear me. Okay. I'm going to skip over the Housing Commission because it doesn't seem like there's anything except that, we're filling vacancies pursuant to the government code section. Once again, I'm just going to always point that out, and that the officers can delegate their positions. We're also taking out the conflict of interest, but we're putting in a good governance provision. Now, Melissa, you are on that commission. Does that work for you?
I'm fine with that.
Okay. Anybody else? Going once, going twice. Okay, on to section 15, living wage. This section proposes to reduce the living wage to no less than the hourly minimum wage pursuant to state law and minimum required leave pursuant to state law. Before, we had health benefits were required. And this isn't just for our non-union employees, this is for our contractors. It goes into their contracts. And so this would take away the health benefits. Leave would be, again, according to state, at the minimum required. And no notice given to employees regarding the earned income credit. I think that's kind of important because I don't understand that. But the rationale for this is what concerns me. The rationale for this change is given the economic impact of the ongoing health pandemic and future uncertainty. It is not recommended that the city supersede the state requirement for minimum compensation to employees. I thought we were above and beyond that. We pay our employees the 75th percentile. To ask our contractors and subcontractors to do the bare minimum, I didn't think that's what Verna was about. And that's the reason we have the living wage within all of our contracts.
Councilmember Menke, this is a citywide provision. It relates to anyone working within the city of Vernon. So those employees that work at Farmer John, this applies to them. In our code, sorry, I couldn't flip to the page fast enough, but the dollar amounts in our code are less than what is currently required by state law. So the purpose of this revision is to bring up the minimums that we require employers in the city of Vernon to pay to that as required by state and federal law. The living wage ordinance is something that would require council discussion and deliberation on whether or not to actually have a living wage. But what was currently listed in our code were dollar amounts less than that currently required by state and federal law. So at this time, all we're doing is let's say that the minimum amount paid is that required by state law, not the lower amount that we had previously listed. And in the future, we'll bring back the living wage ordinance for the council to discuss on whether or not that policy should be implemented and how you would like to implement it.
And I'm not as concerned with the living wage because I mean the amount of compensation, because I do understand that. But as far as health benefits, and just giving them the minimum time allowed as far as vacation, sick leave and the like.
So what that's saying is you need to provide what the minimum that the state provides. Our current code is less than what the current requirements of the state are. So we're
Can
just
you
trying to
tell me
bring
the
this.
difference?
I'm sorry?
Can you tell me the difference? Because it seemed like an awful lot to me, what we have in our current code. I may be wrong.
I think if, hold on, let me get to that section. Difficult to scroll on the laptop. Give me just a second.
I just like to point out how this is a perfect example of how old this is, because our minimum wage, I think, is like $15 now in the state.
Close to that.
Our current code says that hourly rates of $10.30.
But I'm
If
talking
health-
about the benefits.
I'm sorry?
I've already agreed with the portion for the wages. It's the benefits as far as leave and health care benefits.
And the way this has been revised, it's to require that the Vernon businesses provide benefits and leave as required by state and local, state and federal law.
Okay, but is that more or less? That was my question.
What we have in our current code says that it's an extra $1.25 per hour if they don't provide healthcare benefits. So $10.30 per hour plus $1.25, $11.55 per hour. So if we retain our current code, we're only going to require that the Vernon businesses pay $11.55 if they don't provide health benefits.
Okay, I think somehow I'm not on the same page. I'm in agreement that we should raise the wage to the minimum California allows. I'm just suggesting that there is nowhere in here where health benefits or leave is required. I just want to know if those benefits are more pursuant to our statute, because we could change this, right? It doesn't have to be one or the other. We could say, okay, yeah, state law, $15 an hour, let's say, for example, and then benefits and leave. I just want to make sure we're not taking away from the employees.
I believe that by following state and federal law, we are providing additional benefits that are not currently listed in our code. Like I said, the living wage ordinance is something that should be brought back to the council for full consideration. But in order to have a code that is reflective of the minimum amounts required to be paid by state and federal law, this is the change that staff has proposed at this time.
Does anybody have any objection to this other than me?
No.
So it would be okay if we're actually giving less healthcare benefits and less.
We're not giving less.
But you can't tell me that. I wanted to know what we're giving.
Well,
what was proposed.
This isn't what
We were
giving.
giving-
We're setting the stage for the businesses here. So in other words, a business can't come in here and pay an employee $9 an hour. We're setting the limits for them. The limit for them now is $10 and change and health benefits. But if they don't offer health benefits, then that extra dollar goes into effect. I think that's fine because it's in line with the state, rather than having any business come into the city and say, you know what, you're going to work for $8 an hour. I'm okay with being in line. It's up to the businesses on what they're going to pay for whatever position they have available. But I would set it as making it in line with the state.
Agreed.
Okay. If that's the consensus. There's not a whole lot more. Section 17, which is the Vernon Green Commission, which I believe is going to be an important commission in the near future with the goals that the state has set. We are now changing from 2. Okay, let's see. I think I have this confused, but no environmental justice representative, only someone in the business of environmental sustainability issues. Are we having difficulty getting an environmental justice representative? Is that the issue?
The issue with that is that it nobody really knows what that means. So
An environmental lawyer, a judge that knows about those issues. I don't think it's too confusing.
I guess the question is, do we have that title available to represent city within the city?
Right.
Looks like Freddie's on, so he's going to answer that.
Freddie, hi Freddie.
Hi. So yeah, to answer your question, like Lisa mentioned, it wasn't really defined what that title was supposed to be. And typically the way it had been in the past was almost like union rep filling that role. So it didn't define. However, I think now with the whole sustainability and all that, I think we just need people that are on the field that can provide that expertise when we have that conversation, not just environmental justice. So it could encompass environmental justice person. However, the way it was written was very narrow, and we were having a really hard time trying to fill that with somebody that have that expertise.
And I just wonder if we're going from being too restrictive to too vague, because someone in the business of environmental sustainability issues, do you think we should tighten that language up, or are you okay with that?
I'm okay with it, but I will go for, your recommendation wanted to tighten, and we can do that. The only concern we have is sometimes when things are not defined properly, it's hard to fill role because people don't know exactly what they're bringing to the table. So I think through the vetting process and trying to pick somebody, those are the things we would look for. And I think that's why issue kind of make it broad so you can look for people that have that kind of expertise. Either academia, in the environmental justice realm, on those things, you have that. Because it's all also depends on who applies and wants to be part of it. Sometimes you get them just because of the name and they're not being a team player. It doesn't help the commission or advance anything that we're trying to do. So we want to broaden where we get the right people to be on the commission.
I just want to
Right
make
now,
sure.
Freddie.
Go ahead.
Sorry. What are the requirements to be on the board? I mean, on the commission?
So the
Like for
requirements,
each position?
we have the right different. So we had, it was a union, it was a business member. And I don't have the whole list in front of me, but if you can, I can open
If I
it.
can help you, Freddie.
Okay.
We currently require 3 representatives from Vernon's business community, 2 labor representatives. And the way it existingly reads is 2 environmental representatives, one of which shall be from the environmental justice community. As Carol mentioned, she defined environmental justice one way as a environmental judge, or sorry, Carol, I don't want to put words into your mouth.
It's all right,
but,
it's all right. No, you can.
The EPA defines it as fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws. So the problem with the way it's written is that we're not really sure what that means. And so the intent, as Freddie and I discussed, was that we want 2 representatives who are actively engaged in the advancement of environment and sustainability. So they may be an educator on environmental issues. They may be a City of Vernon business sustainability representative. We believed that was the intent. If the council feels otherwise and wants to go in a different direction, we'd be happy to modify this language as you feel appropriate.
It could also be just, being the devil's advocate. It could also be one of the protesters from Farmer John too, right?
That's correct. And that's why you need to vet it out. And I think that was the issue with the original language. It was hard to define who that person is and what makes you be part of the environmental justice community. You know, what's the credential for you? This one, you can actually get based on what they submit to you, the work they've done, the body of work. You can say, yes, they have dealt with sustainability and environmental justice issues, basically. Because, yeah, you don't want to get to a point also where you have people that just basically is going to stop the progress because they have issues with businesses and Vernon.
And, you know, the only thing I need to make sure of, I know when you're here and you're vetting these people, this is going to be done properly. But what happens, Freddie, if you go on to bigger and better things, you become president of the United States, for all we know. That's my concern. You know, I just want to make sure that you're comfortable that the next person would be able to think of it the same way you do. That's why sometimes tightening up the language is important.
And to be honest, council member, I think that's the whole idea. I think when we came, we were kind of saddled with who is this person? And the intent was probably right at the beginning, but it was written in such a way that you really have to go find somebody that meet that criteria. Where I think that even if I plan not to go anywhere, if the city want to keep me, and I don't qualify to be a president, so we don't have to worry about that. However, I think with this really comes to where the hope is you get more people being interested. And then based on if we get more people, then we can really vet them out to make sure that they meet that criteria. Instead of just carving out and says environmental justice community, it really limits the city's ability to get the right people to come in and help.
It appears that it just broadens those that can apply for the position.
Exactly, because people in that kind of community, they kind of, you know, it's you have some people that everything is basically no, because we don't want development, we don't want this, we don't want that. And then you have people that have actually studied this, they have the issues, they're able to bring that to the table. And that's what we want. We want people to say no, but they know it hasn't to be because we don't like this business in Vernon. So regardless what you guys do, we want people to come in and say, these are the issues that we want to deal with when it comes to traffic, when it comes to the air and all those things where it can really add to the Green Vernon Commission. That's the goal.
Thank you very much. Okay, moving on to something that's near and dear to our mayor's heart is the Community Grant Fund. I just noticed that there was a change from one member of the legislature to one member of the legislature. And I'm sure that has this, it's the same issue that the Green Commission has, but I'd like you to address it. And then one thing that was a little bit troubling was to remove the requirement of publishing the grant deadline for applications on our website. I would think we'd want to do that, but I will let you speak to that, please.
Lisa, in terms of publishing on the website?
Right, the deadline for our grant applications. I just
Right.
would have thought we'd want this brought up to let people know so they don't miss the deadline and utilize everything that we have.
I didn't read where it says that they're gonna take away the deadline.
No, not take away the deadline. It,
So that it
The
doesn't
current-
appear on the website.
right.
The
Am I
current-
correct, Ms. Clerk?
The current code requires that, I'm sorry, I'm just trying to find the section. We post the grant awardees on the website significantly further in advance than what our agenda report would be to go out. So I think that this provision has been changed to reflect that.
I think it's also the fact that we're only meeting twice a year versus 4 times a year.
Carol, what code section are you referring to? Just so I can get on the right page. I'm sorry.
Hang on 1 second, because I have 3 different documents in my own. It is, it's section 20 on the ordinance. I think it's 20. Yeah. Okay, 20. Okay, what am I doing wrong here? I have 22, 24. There we go. Okay. It's on page 10 of 14 and I think 9 of 14. And it must be on page 9.
I think that, so in the past, we accepted applications year round. And they would continue to be the deadlines would continue to be published on the website, but this just offers additional flexibility on how we post it.
So we will be posting the application deadlines on our website. That's the only thing I want to make sure of.
Absolutely, but in the past, we accepted them year round, so it was open-ended, but we will make sure that the information is adequately and prominently posted on the website.
And then as far as only one delegate from the legislature, is that because of, again, like Freddie said, it's difficult to find people?
A lot of the times they don't show up. A lot of the times they miss meetings and so forth. So yeah, it's difficult for them to attend.
Okay.
So it's
Since
going
I've
from
been
2 to
here, that
1. Yeah.
since I've been here, we've only had 6 members on the committee because the second legislative representative was not interested or responsive or available. So staff thought that in order to be most efficient and have a full committee, it would be better to modify the membership.
Excellent. Now we're going to move on to section 22 and 23. This is a Freddie issue. The food protection program. The only issue I have is reducing the temperature of holding food from 140 to 135 degrees Fahrenheit. I agree that is the state law. I don't have a problem with that. However, in the articles that I've read, reducing it 5 degrees removes the safety margin. Please speak to that, Freddie.
So actually the best science, and we follow the California food code, which is 135. So when we do go out and we need to cite or anything like that, it's based on the food code. And that is a state mandate that we have to follow. So when this was changed in 2007, for some reason, the city code didn't change to be in line with that. So we're going about the old code that we cannot enforce. So yes, we encourage people to be higher if they can, but the 135 is the minimum they have to meet on the state and the federal level. So that's what we change it to be in line with that. So when we enforce it, because right now we cannot enforce the 140 because it's not a requirement.
And so, and your thermometers are very accurate, right?
Oh yeah, it's calibrated and it's checked, and they need to maintain that by state law, 135, and that's across the whole state.
Okay, I'm finished. If you can believe that, thank you for your patience with me. I
Thank
hope
you.
provided some education. And we got one thing changed. And that, you know, every little change makes a huge difference. Thank you for Miss City Clerk for indulging me. And we can move on now.
Okay, so is there any further technical questions for staff on item number 14?
I learned a lot.
Are
I
there
just want
any-
to say thank you. I just want to say thank you, staff, for doing this and helping Carol out with all of her questions.
Yes.
I'm very impressed with the turnaround. You
Yes.
guys had about a month, so that was pretty impressive. Are there any public comments for item number 14? City Clerk, any public comments?
If I could just remind the attendees, if you're interested in providing public comment, to use the raise your hand feature. I believe it's on the left side of or on the bottom of your screen. Just give them a second to see if there's any comments. I believe you're okay to proceed, Mayor.
Okay, thank you, Lisa. May I have a motion for item number 14?
I think one of the requests was section 2.2 be moved out of the motion to discuss later on limits on the bonds.
Okay, so we will remove that section.
I
Didn't
thought
we already put 100,000 for each one?
I thought
No.
it was recommended by Lisa, but we wanted to discuss it further.
Good point.
That's what my notes
Hold
said.
on, let Arno speak.
And Mayor, yeah, and while the discussion's been going on, I've been doing some research on some of my other cities, and the bond levels for those officials generally seem to be at $100,000. So if we put that number as recommended into that number at this point, then we can move forward on first reading. If you wish to have further discussion on that item, we can hold it over just that one part. So it's at the pleasure of the council.
How does everyone feel about moving forward with 100,000?
I'm good with that.
I'm good with the 100.
Okay. So may I have a motion as is for item number 14?
One more thing. We took out the city council department from under admin also. That was another change. So there were 2 changes.
Right. So with the changes made, do I have a motion for item number 14?
I'll move item 14 with the changes.
I
second
second it.
Okay.
Motion by Mayor Pro Tem Ibarra, seconded by Councilmember Gonzalez, to introduce and conduct first reading of ordinance number 1271, amending various sections of the municipal code in chapters 1, 2, 11, 12, 13, and 15, and directing staff to schedule second reading and adoption for the February 2nd, 2021 city council meeting. And if I could just point out that there are a few sections that are effective immediately, 11, 12, and 13. I'll call the roll. Mayor Lopez,
Yes.
Mayor Pro Tem Ibarra,
Yes.
Councilmember Davis,
Yes.
Councilmember Menke,
Yes.
Councilmember Gonzalez.
Yes.
Motion carries.
Now on to item number 15. City Clerk.
Item 15 is motion pictures, television, commercial, digital media, and still photography productions. The city of Vernon is a highly desired area for filming, and in our goal to be a business-friendly city, I've been working with our consultant Film LA. They process our film permits on making Vernon more accessible to businesses. During that process, I reviewed the city's ordinance and note that the California Film Commission provides model ordinances for cities to follow, and ours was somewhat limited on the provisions that it included. So I'm presenting to you an ordinance that amends section 5.65 of the city's code as outlined in the staff report. The provisions are essentially the same, a little more beefy, and it still authorizes the city administrator to promulgate procedures, which after this ordinance is adopted, will come back to the council for approval in the form of a resolution. We're required to provide our ordinance or any revisions to procedures and fees to the California Film Commission pursuant to Government Code Section 14999.21 at least 30 days prior to adoption. And I did submit the proposed ordinance to the commission back in December, and they have reviewed and approved our proposed ordinance. So if there aren't any questions, it would be appropriate to have a motion to introduce and conduct first reading.
Does the council have any technical questions for staff on item number 15? Seeing that there are none, are there any public comments?
I believe we do have a hand raised.
Okay.
We have Donna Washington from Film LA, which is our company that we use to, a nonprofit organization that we use to issue our film permits. Donna, if you'd like to go ahead.
Thank you so much, Lisa. Honorable Mayor and Pro Tem and City Council members, I just want to say thank you so much for Lisa Pope, her help and leadership and partnership in getting these changes done. The industry is ecstatic about the changes that have been made, and you'll see more activity in your city going forward. The changes that Lisa's proposing will ensure that the city of Vernon is adopting more film-friendly policies, and I hope that we'll see more changes coming along. But thank you so much for your leadership, and thank you to Lisa for her help.
Thank you, Donna.
Great. May I have a motion for, is there any further public comment?
That's it, sorry.
Okay. Oh, no, okay. May I have a motion for item number 15?
So moved.
I'll second.
Second.
Motion by Councilmember Menke, seconded by Mayor Lopez to introduce and conduct first reading of ordinance number 1272, amending Vernon Municipal Code Section 5.65, motion picture production to be motion pictures, television, commercial, digital media, and still photography productions, and direct staff to schedule second reading and adoption for this February 2nd, 2021 City Council meeting. I'll call the roll. Mayor Lopez?
Yes.
Mayor Pro Tem Ibarra?
Yes.
Councilmember Davis?
Yes.
Councilmember Menke?
Yes.
Councilmember Gonzalez?
Yes.
Motion carries.
Thank you. We will now go on to item number 16.
Item 16 is Los Angeles County Fire Code Title 32, and City Administrator Fandino will present the report.
Good afternoon, Mayor and City Council members. On May 19th, 2020, the city adopted Resolution 2020-12, approving and authorizing the execution of service agreement with the Consolidated Fire Protection District of Los Angeles County. And accordingly, and effective October 21st, 2020, the city officially transitioned its fire service to the district and now lies within the jurisdictional boundaries. Upon annexation of the city to the district, the County of Los Angeles Fire Code Title 32 shall be enforced in the city, as the district now has responsibility for fire protection within Vernon. Section 10 of the city's contract service agreement with LA County Fire states that the city shall adopt ordinance of the County of Los Angeles Fire Code Title 32. As such, the first reading of ordinance number 1273 is being heard by City Council at today's meeting. The Los Angeles County Fire Code incorporates the 2019 California Fire Code in its entirety, which was adopted by Vernon in November of 2019 and has been the standard for Vernon. It also includes certain portions of the 2018 International Fire Code. In March 2020, the LA County Board of Supervisors adopted a more restrictive building standard, which is noted in Section 450. Upon preliminary analysis, these are more restrictive standards will largely impact new construction projects in Vernon, but will be limited impact on existing businesses in Vernon. In the course of normal business, should it be found that the routine issues arise with our Vernon businesses, the city will work with LA County Fire staff to collaborate on solutions which would potentially lead to amendments to the code that are satisfactory and agreeable to LA County Fire and Vernon. This concludes my presentation.
Does council have any technical questions for staff on item number 16? Are there any public comments for item number 16?
We're checking, Mayor, just a second.
Sure.
No hands raised.
Okay, so may I have a motion for item number 16?
I move.
Do I have a
Davis.
second?
I'll second.
Motion by Councilmember Davis, seconded by Mayor Pro Tem Ibarra, to conduct first reading and introduce ordinance number 1273, repealing and replacing Chapter 7, Article 2 Fire Code, adopting the 2019 edition of the California Fire Code, 2018 edition of the International Fire Code, and the 2020 edition of the Los Angeles County Fire Code, Title 32, Consolidated Fire Protection District of Los Angeles County Fire Code, ratifying the more restrictive building standards contained in that code, and direct staff to schedule direct staff to schedule a public hearing on February 2nd, 2021 for second reading and adoption. I'll call the roll. Mayor Lopez,
Yes.
Mayor Pro Tem Ibarra,
Yes.
Councilmember Davis,
Yes.
Councilmember Menke,
Yes.
Councilmember Gonzalez.
Yes.
Motion carries.
Now we will go on to oral reports. City Administrator Fandino, do you have a report?
Yes, I do, Mayor. COVID-19 vaccine report. The health department is working with LA County Department of Public Health to vaccinate Vernon employees. The department also sent out a vaccine interest survey on Friday to Vernon businesses. Clerk has a copy of the email if you want to, we'll share it with you on the screen, I believe. The survey results will be shared with the county to determine the amount of vaccines needed for Vernon. Staff also has a site visit scheduled for Thursday with staff member from LA County Public Health to check out the trailer and vaccine storage freezer. So it's our intention to offer up our services here in the city, utilizing the trailers that are in place and also the freezer capacity, not only here at City Hall, but also in some of our businesses to assist with the vaccine push out. Freddie, I don't know if you want to add anything.
Ready.
Okay. And then secondly, PD is also working with the area chiefs to get vaccinations pushed out. But because of some of the challenges we are working with currently with the inauguration and some other issues, this is kind of pushing back the vaccine rollout with area chiefs. So Chief Miranda, I don't know if you want to talk about that as well, if you're available. Okay.
Hi, Carlos. Well, yeah. Right now, we're looking at the first week of February for all law enforcement in the county. We're taking a step back because of the inauguration preparation and plans for tomorrow. We want to ensure that all will be ready for that. So it's going to get pushed back a little bit, but looks like the first week of February.
Okay. So the other thing we want to talk about is any issues of discussing items for tomorrow, that anything that we can expect here in Vernon, Chief?
Not in proper, but in downtown LA. As a matter of fact, at 3 o'clock this afternoon, I'll be joining Chief Michael Moore from LAPD, Alex Villanueva, our sheriff, Gil Garcetti, in a press conference to make some comments to the community about law enforcement and our expectations and just our role in the county as, you know, keeping it safe and asking for everyone's cooperation. But at the same time that we all stand shoulder to shoulder to keep everybody safe. And that's for the inauguration. That press conference will be this afternoon at 3 o'clock. I plan on being there, and we will, it'll be at the Hall of Justice downtown. But nothing in the city of Vernon, but our neighbors, yes.
We'll be ready. We will be ready to assist in any way. So I know it happened last year and it seems like a long time ago, but I'd like to say a quick words about the Operation Santa event that took place on December 16th. Vernon Police Department, in coordination with our city council, city administration staff, and LA County Fire, helped organize a drive through the soccer ball giveaway for Vernon Elementary School students. The remaining soccer balls were delivered to the school and ensured that every student did receive a soccer ball. Later that night, Vernon Police Department also participated in Operation Santa, handing out gifts to members of the community while they enjoyed a visit from Santa Claus. Although from a distance, he was in his chair and he was waving at cars as they were going by. And the digital light show in front of City Hall. I do want to say thank you for the PD for helping us put that digital light show on. And I will tell you that next year it will be better, and we are planning another digital light show at City Hall. For the residents that could not make it, Vernon Police Department officers delivered their children's gifts to their doorsteps later that night. So I just wanted to reach out and say thank you to all the city council members that showed up and helped out with the toy drive. And it was a long day. It was a huge effort by both Vernon Police Department and City Council and LA County Fire. So thank you to all for a great night. And Chief, correct me if I'm wrong, but we did receive many thank yous that were delivered to the police department for our help.
We did. And we even got several voicemails left on my office here from random motorists driving through Vernon, just telling us that they appreciate the lights in front of our in City Hall, that they lighten up their day every day. And it was it provided a little bit of inspiration on their way home from work at night. So some really good feedback. But for that whole digital show, that was all coordinated by our detective Eddie Hernandez, and he is pretty much a genius when it comes to electronics and lights. And Carlos has authorized him to go bigger and better next year. So we're excited about next year.
That's right.
Sounds good. Can't wait.
And then the last note, we are bringing back all our field crews. We've worked with HR and the different departments to ensure that we have an operational plan that ensures the safety of our crews here at work. So today we're splitting up our crews into different pods. And I just want to say that I'm very pleased with the rollout plan. And so we are back at full strength with our field crews here at the city and in different pods that have been assigned to the different work groups. Be safe out there. COVID is the numbers remain high, and we want to get as many people vaccinated as quick as possible, and hopefully that can happen within the next couple of weeks. And that concludes my report.
Are there any reports from council?
I just have one thing. Will you guys be able to vaccinate those of us over 65? I'm selfishly in a hurry to get that done.
Yes, the plan is to vaccinate individuals that are over 65 and older. We're hoping to roll that out as quick as possible. So Freddie is working with LA County to try to get those vaccines allocated for Vernon.
To my understanding, Hilda Solis signed off yesterday for them to expand on that as well, because
sorry.
it's been a slow rollout.
Mayor, I'm sorry, we are having some technical difficulty. If we could just pause the meeting for a few moments.
Okay.
I'll let you know as soon as we're ready to come back on. Okay, you can unmute me, please. Mayor, we're back on. Councilmember Gonzalez is here with us via the telephone, and I'm sorry to interrupt you, but please go ahead.
So I was addressing Councilmember Menke. We will be rolling out a plan to vaccinate our residents and business employees that are 65 and older here in Vernon. And I will give an update by this Thursday as to where we are with LA County so that we can try to get this vaccine pushed out as fast as possible. And I think the mayor was also indicating that there was, Hilda Solis did sign something.
There's no vaccine supposedly, so I was hopeful
Correct.
maybe we'll be getting some. So thank you, Carlos.
Diana, did you have something you wanted to add? Thank you. Okay.
I did want to make a comment. Carlos, is it possible for us to look into the implementation, or what is our current rule in regards to face coverings within the city? I know LA implemented a more stricter policy when it comes to face coverings, and I was just curious to see where we stand on that and what we can do within the city of Vernon.
Okay, what I'll do is I'll reach out to our health department and we'll give a report back to city council at the next meeting.
Thank you. Do we have any other reports from council?
Yes, I want to request staff prepare a report on the Vernon Housing Commission activities. I've been following it and I get the whole lottery and everything, but there's a lack of transparency from the lottery through the selection and the people who qualify when they move in to the properties that are vacant.
I'm not exactly understanding the question. What is it that you'd like to see?
I would like to see a report on the activities here for the Vernon Housing Commission. What's going on?
You're on mute, Mayor Pro Tem Ibarra. It looks like you're speaking.
Sorry, are you asking about the quarterly report that's issued every quarter?
Something, I mean, because I've been here with the city and I want more information here. We've never heard any report or anything on the Housing Commission.
We do give a report, and it's a quarterly report that we give out at the Housing Commission meeting. So are you looking as to
Is there a specific request?
Yeah,
Do you want the same? Do you want the same report that's issued every quarter when we have the housing report?
Here, yes.
Okay, well, we could send the last report that was sent out, and then I think the next one is scheduled for March. I do think that we are going to have a special Housing Commission meeting within the next 2 to 3 weeks. We'll have something scheduled.
Okay.
Okay, so we will now go on to closed session for agenda item number 17.
Oh,
Will there be another link for the closed session item being sent out?
There's going to be a new link that'll be sent out by IT. So we'll
Okay.
disconnect from this. We'll take a quick break, and then we'll come right back with the closed session item.
Okay.
Sounds great. Thank you.
Have a wonderful day. Happy New Year, everyone, and please be safe.
Yes, thank you. Bye-bye.